met result. This matter was reached at 8 May month. This matter, madam, but I'm going to mention matter 8 on 8 May it was picked, madam. The matter has not been listed. It was also directed to make payment of substance allowance, and 8/5/2022 was fixed for compliance. But the issue is not listed any date.
Have it on 15th.
Pardon?
15th.
Right. This family pension matter was listed on 8th of February and they left out. My lord, family pension matter, my lord, and it was listed on 8th of February. It left out, my lord. They have not listed. Monday.
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 This month?
My lord.
Monday of this month?
My lord. This 15th, my lord. Might be, my lord. 15th, 16th, or 17th, any day, my lord.
I'll have it on 22nd.
22nd.
I have kept one word about Monday.
Yes, which is it. So this matter is video of scale of pay regarding the copies, my lord.
Huh?
It is video of scale of pay regarding the copies, my lord.
Oh, that matter. In fact, that day as I was going through one judgment, you also find out that thing which has been given in a recent judgment by the division bench. It may help you out. There, the same principle was given, which has been given to grade 4. Now it has been given to grade 3 also. The same principle was adopted. That why they should not also be getting the minimum of scale of pay. Your case was stenographer, no?
Copies.
Copyist in the foreigners tribunal. Yes. Okay. We'll have it when? I can't hear you.
That's why you're not for minutes.
We'll have it on 17th May. I think it's not good.
Item number 39.
Yes, now tell me.
Item number 39.
39.
39. Maybe 17. Oh, next question.
17th.
35.
Why? Nine.
Item number.
The request of the learned counsel for the petitioner. Matter stands adjourned for today and to be listed again on 31st of May.
Happy to Lordship. Item number 55.
Hey, it would something. As the government, the WHO has already said that COVID is almost everything is over. I think it's high time we have to remove these glasses to have a better audibility in respect to this. Anyways, tell me.
Your Lordship, item number 55.
55.
Yeah. Humbly and respectfully adjourn the procedure of the case for today, Your Lordship.
You want an adjournment?
Yeah, I've already informed the opposite party.
Okay, item number 55 at the request of the learned counsel, matter stands adjourned till 4 weeks.
Lordship, item number 65, Lordship. Today I have filed our additional affidavit, Lordship. So kindly call for the Can you tell at 2 p.m. Lordship?
Why?
Item number 65. I will wait for my turn.
Wait for you. Did this court, Mr. Counsel, Mr. Balbura, did this court grant you the adjournment, the permission to mention the matter today, to list this matter?
Lordship.
This court given.
Lordship.
Then we'll take it up,
Yes,
upgrade it.
Lordship. Much okay.
I beg to mention for listing my lord 4856, my lord, and regarding non-payment of pension.
Non-payment of
Pension.
pension.
Yes, sir.
Why it has not been listed?
It was last posting on 21st March.
Then
Then not.
why haven't you inquired with the registry? Huh? Inquire with the registry. Unnecessary mentioning it out here doesn't make sense.
That was
Because here this will change everything. If I keep on fixing, you see, my list has now gone to 68.
that
You
was
see, other courts, they are having 42, 48 matters. Then,
that was not fixed, my lord.
then something is wrong. So ask the registry, make a request to the registry to list it, then they will list it. Don't you think so? Or if I fix it, I'll fix it in the month of June. 5th of June.
Another payment I have for withdrawal.
Withdrawal will have it on,
Tomorrow.
not tomorrow. We'll have it on 12th.
I beg to mention for application of item number 64. In the
Why?
in the last occasion, your honorable court has given the liberty for mention for application, Lordship, because the.
I have given in the order,
Yes, your Lordship.
then it will be. Huh? It's already there.
Value.
You inquire with him because these matters, if I have given the liberty, it will automatically come.
May it please the lord. Lordship, I beg to mention item number 22 from the list.
22.
Yes,
Why?
my lord, with the consent of either side, I beg to mention this matter for my lord Passover.
For?
Because my lord, I am unable to contact my client through telephone.
But Mr. Counsel,
I have to take
this
some-
matter is of 2017. Does it look nice for adjourning this matter?
just for today.
After all, this court is taking up matters of pension, suspension and area salary. And if you mention you are not being able to contact and now it is almost 6 years, doesn't look nice. We'll see what is to be done if the matter reaches. Yes,
Lordship, I beg to mention item number 42, Lordship, for upgradation of this sheet.
was it earlier given? No.
So, Lordship,
Why then? Why do you want the upgradation?
paper relating to only for minimum scale of pay, Lordship. We are different.
Item number 42,
Yes,
by order. Who had mentioned this matter and before which court?
I think Honorable Justice,
First of all, when I give a permission, it has to be urgent. Otherwise, I don't give. So, minimum, your cases of minimum scale of pay,
yes, Lordship.
that those Upendas,
Yes, Lordship.
chalo, we'll upgrade it. Let's see, we can dispose it.
I do.
Item number 63, my lord.
63
There is also order for upgradation, my lord, by this honorable court, my lord.
for upgrading.
Yes.
No, it will be done.
May it please the lordship, may I pray for listing of an item. The matter was last listed on 19/09/2020. Matter relates to non-payment of pensionary benefit.
Then why haven't you asked the registry to list it? Ask the registry, request the registry to list it, then it will happen. Because if I give you this permission, it will have a cascading effect on this particular list. You approach the registry, we'll see later on. If the registry doesn't give you.
May it please, your Lordship, I beg to mention item number 44, Lordship, for
40?
upgradation, Lordship. For upgradation, Lordship, item number 44. On the last occasion, Lordship, this honorable court was directed to.
It's there, it's there. So you, any upgradation, you just inquire. If there is an order, it will be automatic. There's no necessary. Yes, madam.
May I please, your lordship, pertaining to item 72, your lordship, supply list,
There's a item 72 also. Okay. Oh, yeah, lot
Your
of
lordship,
matters. Oh,
instruction,
there's a supplementary list. Also.
supply list, your lordship.
Yes.
Instruction awaited, your lordship, and the petitioner side showing his name is on absence, leave of absence, your lordship. So kindly 2 weeks time may be granted to obtain instruction, your lordship.
So there, this matter has come, I think matter must have been listed. There is a direction asking you to apply, obtain your instructions.
Instruction awaited, your lordship.
Okay. Where the petitioner is not there?
Your lordship, his name has been reflected in the leave of absence, your lordship. In the cause list. Sir, S. Nath.
Where? Oh, yes. From 8/5 to 14/5. And what about the other one? Jdas. Then you want an accommodation, ask him, call him up. Because this court would adjourn the matter for 4 weeks. Then the petitioner council
I will
may be
inform
sad
them, your
about it.
lordship.
Huh?
I will inform them, your lordship, as instruction is not
You again mention at 2, informing, then only. Yes.
deeply obliged.
Lordship, I beg to listing for mention for admission.
What? Admission?
Yes,
Why?
not listing. Not listing.
Obviously, that is why you are mentioning it, but why?
Urgency. Urgency.
What is the urgency? Improve, think about it, and then come back next week. Mention again. Yes, yes, madam.
Yes, please, Your Lordship. Lordship, item number 27, the Honorable Court had directed the respondent to file the affidavits by 3 May, 3rd May, Your Lordship. They have not yet filed the affidavits. And when we talk, the Honorable respected sir said that they will be seeking instructions from the
Yeah,
respondents.
the complete instruction is awaited, lordship. Although incomplete has been received, but
That was the case of trained and untrained teachers.
Untrained.
huh?
Your
trained and
Lordship.
untrained.
Yes, Your
Yes.
Lordship, graduate teachers.
Yes, and as to whether there is any difference out there, because the cadre doesn't show anything about, cadre mentions about trained and untrained.
lordship,
teachers.
lordship.
Yes, then that's the grade pay of 6,700.
6,800 and asking for
Ah, I
8,700.
remember.
8,700. I'm saying.
Yes, what, why it is awaited?
Lordship, incomplete instruction has been received, lordship, so it has been directed to the DO to furnish the detailed information. So lordship, allow 2 weeks time, we will file our affidavit.
Maybe fix by a date or
Okay. Your name?
Pidas, Your Lordship.
PDAS, the learned counsel for the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. Mr. R. Babuzari appears for the Finance Department. By the order dated, I've asked them to file the affidavit when?
11th April.
11/4/2023, this court had directed the Elementary Education Department to file an affidavit,
As well as finance.
as well as to the Finance Department. However, it seems that the affidavit has not been filed, and Mr. P.N. Sharma, the learned counsel appearing for the Elementary Education Department, submits that complete instructions is yet to be received. Taking into account the same, let the matter be again listed on 31st of May 2023. Both the Finance as well as the Elementary Education Department shall file their affidavits without fail by 29th of May.
Problem.
Number 51, madam, taken as the last updated matter.
50?
51,
Why?
madam, the non-payment of salary since 2013.
Did I pass any order for upgrading?
No, madam.
So then everybody is a salary business.
Last time it was listed, but due to paucity of time.
We will see if it reaches today. But no upgrading. Yes.
I know one, power drill.
Yes.
Allowed to the liberty to file affairs because
Hey, there the problem arises. Why the liberty?
lordship.
With the said affidavit, said time, the petitioner has liberty to file an additional affidavit. Yes, what is the matter about that matter? I remember
Lordship.
you were not
In
there
some,
at that point of
because
time. Your
this case
junior
and
moved
everything,
it,
lordship would-
and then again the matter came up. I wanted to dismiss it. Then I asked you to file an additional affidavit.
Lordship, I feel lordship, I pray lordship for annexing all these documents, lordship, it will for fresh petition in next.
Heard Mr. K. A. Majumdar, the learned counsel, appearing on behalf of the petitioner. Ms. Pidas?
Yes, your lordship, I have taken consent, your
Oh,
lordship.
no. You are appearing in this matter. Then I have asked you to mention it too. Mention it too, not before that. Mr. PHC does not appear. Mr. R. Babuzari appears for the Finance Department. And Mr. You have PhD? At last. Mr. S.M. Hassan appears for the PhD department and Mr. A. Chakraborty appears for the pension department. And anybody from the accountant general? Yes, Mr. R.K. Talukdar appears on behalf of the accountant general. The learned counsel for the petitioner submits that although this court had directed the petitioner to bring certain relevant aspects of the matter by way of an additional affidavit, but upon filing that instead of filing the additional affidavit, the petitioner wishes to withdraw the instant writ petition and file it afresh by bringing on record all the necessary documents. And as such, has prayed for withdrawal of the instant matter. Taking into account the said submission, the matter stands dismissed on withdrawal. However, liberty is given to the petitioner to file afresh.
Item number 2, promotion.
Hey, can call monopoly use. Yes.
My lordship,
Why didn't you appear on the last occasion?
My lordship, I apologize, my lord. My exam dates were changed. On third there was exam. My senior has come, but he was late, my lordship.
Who was late?
And Islam.
Very well.
My
Now,
lordship,
what is your case?
my lordship, regarding this matter, my lordship, similar case is pending before this court, my lordship. Kindly this matter will be tagged along with.
You the better ask that my lord will dispose of the matter now, so that the said order can be applied to the similar case. That is a better argument. Yes. Now tell me, what is your case?
He is not getting paid. He is not getting paid despite my 34 years of his service.
He is not getting a pension
Yes,
despite having 34 years of service. 34 years of service as what?
As WC Khalasi, my lordship.
Khalas. Now, in what capacity?
There is-
Master role?
There is a
Were you confirmed? Were you confirmed at any stage? Regularized? So you are not in the government service?
no, my lord.
Then your pension has to be from spring from a service. What is your basis? And what is this similar matter pending there? Yes, which department is this?
PhD department.
PhD department.
Same department case is pending, sir.
Now the petitioner worked as in what capacity?
What judge Khalasi, my lordship?
Worked as Kalachi Road.
And he retired as a work charge. You were not regularized.
No, my lordship. Similarly, incumbent were-
What are these documents enclosed as page 16, 17 and all? This is given to somebody else.
Yes, my lordship.
Oh, Mr. Counsel, are you not prepared with your matter?
Yes, my some.
Tell me,
Somebody else.
what are these documents for?
Somebody else. It was given, my lordship.
Were you regularized at any point of time?
No.
Were you regularized? Why have you enclosed Annexure 6? What is this document? Babaruddin Majumdar. Where is his name? His name is not there. Oh, there, his name is there.
7, my lordship.
Retired and so on. Regularization of service of WC, we have the honor the following person that he has retired, expired after rendering more than 30 years of continuous service. They were dropped while regularizing all the WC during the year, although they are required particularly submitted as sought from so and so to the higher authority and when called for, but unfortunately the services have not been regulated for which needed the pension papers to be prepared. In this connection, a statement from the so and so. Therefore, I would request you kindly regularize. So this is a request.
Request, my lordship.
Prayer for regularization of benefit, nothing else.
Not regular. My lordship, there is one office of memorandum dated 12 September 1990. Can you lordship
That is the one if a person has 20 years of service and not necessary. So it is on your case is on the basis of that. Isn't it?
Yes, my lordship.
But Mr. A pension good. But Mr. Counsel, next time be prepared.
Yes, my lordship.
That document is your, what do you call, your main document. You are mentioning about the document at 6 September 2003, that office memorandum.
It is 12th September 1986.
Yes, 12 September 1996 do you have a book like this? And you are doing a pension matter? Very well. Heard, Mr. Your name?
TK, my lordship.
And so, name. Okay. This has been done by e-filing.
No, no one.
Well, naam sab nahi diye the. Your name is TK Day.
TK, Kamal Kumar.
The learned counsel for the petitioner, Mr. SM Hassan, appears for the response number 1, 2, 3, 4. Mr. R.K. Talukde appears for the response number 5. The case issue notice making it returnable when?
After 3 weeks.
Okay, we have it on 19th of June. Issue notice making it returnable on 19th of June 2023. As the respondents are duly represented, extra copies of the writ petition be served upon them by 12th of May 2023. The case of the petitioner herein is that the petitioner was initially appointed as a Kalasi on 23/5/1987. However, full stop. Subsequent thereto, the petitioner continued to render his services. And there has been certain recommendations also made to the authorities by the authorities that the petitioner's services ought to be regularized. Be that as it may, the petitioner had retired on when? When did you retire?
31/12/2021.
31/12.
12/2021. 31.
31/12/2021. Where is that mentioned? 31/12/2021. However, the petitioner have not got any pension for which he has approached this court. The learned counsel for the petitioner have referred to an office memorandum during the course of the hearing, being office memorandum number PPG bracket P 196/92/61 dated 6th of September 2003, issued by the Secretary to the Government of Assam Pension and Public Grievances Department, wherein it has been mentioned that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. It is therefore the case of the petitioner that as the petitioner have rendered for service for more than 34 years, the petitioner also should get the benefit of the said office memorandum which have been denied by the respondent authorities. The respondent authorities on the next occasion, on the next date, shall apprise this court as to why the petitioner is not entitled to the aforementioned office memorandum.
My lordship, one order of the Supreme Court is also there.
That is of Justice M.R. Shah.
Yes, my lordship. No, Nagaland.
Yes, both of them. Supreme Court is not single bench like IMC division. Yes.
See,
Yes, Mr. Hussain.
May I please, Your Lordship?
Yes, what is your case?
Matter relating to suspension, Your Lordship.
Suspension?
Yes, my lord. I was suspended, Your Lordship. Thereafter, within 90 days, no.
Suspending an operation of the impugned order dated 1/11/2022. Why were you suspended? Because of arrest?
I was arrested in a criminal case, my lord. It's relating to another selection and appointment, your lordship. And after my arrest, I was suspended. And within 90 days,
When were you suspended? Suspended?
suspension order. is that-
Suspension order, I know. It is given out here in a prayer out there. At 1/11/2022. When were you released?
From jail, my lord.
No, from where, no, from the jail.
He got the bail from
I got the bail, my lord.
2/12/22. 2/12/22.
2/12/2022.
He got the
Okay.
bail.
And when did you communicate?
Well,
You have to communicate the people, na? That, look here, I am no longer inside the jail.
Thereafter, I have been reported in my posting case, my lord. And thereafter, after expiry of 90 days, I was served with the first show cause notice, my lord. But the thing is that, my lord, thereafter, although within the 90 days show cause notice, charge memo is required to be submitted, it is not submitted. And even if it is submitted, my lord, there should be a review, my lord, of my suspension. That was not done yet, my lord.
So, what do you want? A review?
My lord, as because.
We direct you.
My lord,
Yes, Mr. Dhod, why don't you do the review?
Review, my lord, already inquiry officer has been appointed since.
And that is for department to proceed.
Proceeding, my lord.
But suspension, are you not supposed to review?
My lord, that instruction I have to seek, my lord, that whether review was done or not. His case is that, my lord, show cause notice was issued to him after just expiry of 90 days.
But that is immaterial.
There is no immaterial cause. He was inside the jail, my lord, and he once he comes out, then only, my lord.
When did the show cause notice happen?
my lord, first show cause notice was issued on
8/2/23.
93, my lord.
8/2/2023. And you were released from bail on 2/12/2022.
22.
So this is within
No, my lord, I released
6 days thereafter.
20
When did you inform the authorities that you look here, I have been released from bail?
I'm immediately
When?
I have taken instruction.
No, that is the most pertinent in view of my judgment in Rafed Ali.
My lord.
Yes, my
Till you don't inform, the question of getting the right does not arise because these authorities, how will they know?
So far, my instruction, although I could not know that date, my lord,
Hmm.
so immediately after release.
Immediately means here also, immediately is, we are concerned about this thing only.
Exactly.
Now,
my
if you see the review, if you see the particular, what you call, the judgment in Ajoy Chaudhary does not say put a time period for the purpose of review. It does not. But there is an office memorandum of 4/2/2020, wherein it says that the review has to be made within 6 months. 6 months is not over. Then what is your case?
And his show cause was issued after expiry of 60 days only. If we go by this High Court, my lord, the bail order. The bail was granted on 2/12/22.
2/12/2022.
Meaning thereby 8/2/23 show cause was issued. It's within 60 days, my lord. Just within 90 days we have.
Within 60 days? How can it be? I don't know what is the calculation you are having. But for me, it is from 2/12 to 2/1, 1 month, 2 months. 2 months only.
2 months.
Then,
No, my lord.
Yes,
from
2 months.
From the date of suspension, my lord. From the date of.
no. That obviously you cannot because just for example, I give you a point. A person is suspended for is inside the suspended in view of his arrest and he is there behind the bars for 1 year. Can you be reinstated by virtue of 6(2)? No, because the basic requirement is that you have to be outside the custody.
Outside the custody.
Then
I am outside the custody in my on
2/12, and then you have to inform the authorities. Then look here, I am outside. Now, after you inform, then a 90 days period has to be recount, not from that initial period. Because that judgment which I have given has not been set aside by the division bench. So that law holds. Rafed Ali.
My lord,
So you have any other ground other than this time period mentioned
and secondly, my lord.
on
secondly,
arbitrariness? the continuation of the suspension is arbitrary, not for Ajay Chaudhary or anything otherwise.
And secondly, my lord, is the appointing authority. My appointing authority is the Office of the Director General of Police. I was appointed as the Assistant Inspector General. That is the appointing authority, and the appointing authority is the disciplinary authority. But my suspension order is the Superintendent of Police Railway.
Your suspension order is who?
Superintendent of Railway Police, my lord.
Huh?
Superintendent of Railway Police.
Superintendent of Railway Police.
And DP
Okay,
also told
but
my-
is he not also the disciplinary authority?
Authority and
But appointing authority is the.
Now, in your reply, 8/2/2023 is the show cause. You have submitted a reply on 16/2. Have you said that this show cause, this you had no authority to issue? Because the disciplinary authority will be the appointing authority. So, and that appointing authority has issued the show cause. Why haven't you challenged it on that ground?
That is a salable ground.
Then.
Question is, my lord, fairly speaking, my lord, my instruction is after filing the focus notice, my lord.
I think you withdraw and have after some time, if you find any illegality or any continuance is much more, then you should approach the authority. Well, I'll issue notice, but issuing notice out there, nothing is going to happen.
I can issue notice, my lord, and in the meantime, I also the queries your lordship has put me. I can take those queries from my mind, my lord.
Because from as of now, there is no violation to Rafid Ali or Ajay Chaudhary, nothing, neither the circular of 4-2. Now, what is the other ground on which, if you want to build a ground on arbitrariness, if you want to build a ground that the continuation of the suspension order is unreasonable, very well, you can bring, but have you brought it out here? If you have not brought it, don't you think it is required to be brought in?
If to the notice, I will take instruction. If after instruction we get anything, then I will withdraw this.
Yes. So we will do one thing, we will defer the matter today. I won't issue notice. At the request of the learned counsel for the petitioner, matter stands adjourned till when? Okay, till adjourned till 19th of May. You read that judgment, Rafid Ali, because that is required for your purpose. And see the circular of 4/2/2020, because that makes it clear. The what you call, the review has to be made within 6 months.
Arbitrariness and.
So yeah, if you have, yes, your
regarding
entire case hinges on this, nothing is going to happen.
Jurisdiction.
Now
So
for-
that when the client seek my instruction after filing the focus reply. I'll your best.
Yes, Mr. Dutta.
Right, my lord, this is basically a second round of litigation with regard to the claim of the petitioners for the grant of pension under the 1969 rule. Now, the authorities have previously, there was a direction from this honorable court to consider the representation in the light of the attending factions.
Not be set aside any issue.
And now the authorities have decided the representation but rejecting the
Oh no, what is your claim?
claim is for grant of our grant of pensionary benefits under 1969 rule.
69 rules.
69 rule.
Why?
The reason is that the past services have been considered by the respondents for all other purposes like grant of gratuity benefit or leave encashment, but for the purpose of pension, they are saying that past services are not to be counted. And they are taking the plea that since we were brought into the mainline departments under the state in the year 2016 and 17, that is after coming of the new pension scheme, therefore we will not be entitled.
But were you brought within the affairs of the government prior to that?
Yeah, we were all along under the government. Only difference is that, my lord, there was the direction of the central government was that we were to be absorbed in the mainline departments. They described the.
So you were appointed in a scheme?
No, we were appointed under vacant posts in the DRDA. Now, the direction of the central government was that.
Then if it is a post of the state, how could the central government direct?
No, the scheme was formulated that the state will give the appointment. But
So it is on a scheme.
No.
So your appointment is on a scheme.
No, under the agency created by the
Understood,
government.
but isn't it on a scheme?
The policy was like this, that the funding will be 90% borne by the central government 10% by the state government. One of the conditions being that we will have to be brought into the mainline department within a period of 3 to 5 years. That was the direction given by the state government. They did not do it. Many states did not do it. In course of time, they realized that since all other states had already completed the exercise, so state of Assam also took a decision and absorbed us in the mainline departments. We are also working under the Panchayati Raj, Panchayat and Rural Development Department. Now, this absorption had taken place in the year 2016 and 17. Therefore, they say that the past services that you have rendered so far as pension is concerned, it will not be counted. And
How can it be counted?
Now they are counting the pension.
Unless you seek a declaration or you see that there should be a direction that the governor exercises the powers under 31. Thereby giving, number 3 will definitely come in. We are having the 3.
Yeah.
The one is that he is in the government service.
Yeah.
He was not in government service because it is in a scheme. There are many judgments of the Supreme Court on that. And the last one of it is for Mr. Nanda.
Yeah.
That is the last of the judgment. Now, the second aspect of the matter that your appointment has to be permanent and substantive, which is obviously no, because it was in a scheme. And the third is the payment from the government. The services were paid. You may come within the third. But 1 and 2 can be done away with by a declaration by the governor.
Yes.
That has not been done.
Now, interestingly, my lord, what has happened, there was a cabinet memorandum prepared so far as the proposal, the sanction of the governor is taken in that line. In fact, my lord, the matter also went to the judicial department for their opinion, because similarly situated other departments are also there in the under the government. And in case of irrigation department, they had done similarly. They waived the requirement and granted them pension. Here, when the judicial department had given the opinion, they also said that likewise in the case of irrigation department, this can be done here. But regardless of this, my lord.
But irrigation department, if I remember correctly, they were under a particular scheme. And immediately at the time of their appointment orders also, they have been specifically mentioned that they would be entitled to the 69 rules. Check out those orders in the irrigation department. Isn't it so? Who was appearing in some irrigation department?
But in the case, and interestingly, Lord, I have specifically pleaded in the case, at least 3 persons we know who are similarly situated with us, they have been granted the pension benefits under the 69 rule. Because the prevailing opinion of
Are
the
you
law,
challenging their being granted, or you want a similar?
I want a parity. Now,
but can this court give a parity on the basis that somebody else has been granted?
The reasoning is that, Lord,
unless the law permits.
My lord, the reasoning is that the prevailing opinion of the judicial department was that likewise in the case of irrigation department, similar benefits can also be extended to us. And
But in your appointment order, was it mentioned to that effect?
Well, the appointment orders are not with me right
More
now.
particularly, if you see the permission under judgment, there is also a scheme on which these people were appointed. They were earlier working in a particular scheme under the state of Bihar. Then they were brought, Bihar was bifurcated with Jharkhand.
Yes.
And then they were brought, those people came in this particular scheme to Jharkhand. And they were then given an appointment out there, wherein further it has been mentioned that for the purpose of their pension, they would be granted the benefit out there. Their earlier period of service shall be taken into account for the purpose of pension. Then the Supreme Court, more particularly in paragraph number 31 and 34, categorically mentioned that when they have been brought into the service on a particular date, how can the earlier period of service could be taken into account? That too when they were appointed on a scheme.
Now, here, my lord, the situation is little different in the sense that even the respondents are recognizing the past services for all other purposes except pension.
Because that is the requirement.
Except pension. The reasoning.
Let us assume the respondent accepts also. But if the respondent, the government issues a declaration to that effect in terms of Rule 31, it is a different aspect of the matter which they can do it. But having not done so till now, then
it was only at the stage of, my lord, the file was processed as the correspondence goes, my lord. the department put up the request and it was to be placed before the cabinet and subsequently to the governor for consideration of this matter on this aspect. It is only at that point of time that the finance department took this objection. Otherwise, all
You know, the main problem is always with the finance. Yeah.
now while taking this decision, my lord, they have overlooked the observation and opinion given by the law department, the judicial department, and the other department, even the panchayat and rural department.
But in view of the rules of executive business, more particularly Rule 10, the finance can obviously have a say on that.
No, these they can have a say. Question is, my lord, whether they are not.
And more particularly that particular act, na, AFRBM Act.
And more particularly, my lord, the question is whether they are not acting in an arbitrary manner. Because in case of one class of employees, they are allowing it to happen, and in case of these two petitioners, my lord, they are holding it up. That is why, my lord.
No, Mr. Doctor, that aspect would duly apply where if the rules permits, if the rules does not permit so, then somebody being given an illegal benefit does not confer a right upon you.
No, I do not say, my lord, the rules don't permit. I say, my lord, that the discrimination that they are making in applying the rules. Because if you
understood, which means in applying the rule means first show me that the rules permit. You permit, then obviously then there is a discrimination. But if the rules does not permit, then they have given someone some illegal benefit. Does not mean that that benefit has to be given to you.
So, my lord, the previous
that is what I could find out in all the teacher matters also.
But in the teachers' case also, my lord, in the case of secondary teachers, your lordship has said that regardless of the fact that they were brought in under the fold of regularized service at a later point of time.
No, they were. I never said that because they were not brought under the regularized service. No. As regards the stipendiary teachers, they were appointed on a particular date. On that very date, they entered into the government service.
Yes,
it is a sad thing which I have not mentioned. It is a sad thing that these people were deprived in because the Rule 4 not to get their confirmation within the period of 3 years. It's a sad thing for which they are. But the only reason why they were not given is that the regular scale of pay was not given to them.
Yes.
Which is not the mandate of the rules of 1969. Rules of 1969 perceives 3 requirements to that effect. For the purpose of first, that he has to be in the government service, which they were. They have to be permanent and here because they were, because of Rule 4 of the conduct rules. And number 3 is that they had to be paid from the government. Maybe not the regular scale of pay, but they were paid 900 or 1800 rupees. That was done. But if you see for the purpose of the drop teachers, the question is different because they were never brought in. Then you see the case of the OBB.
Yes.
They were, although they were having a scheme where 90% of the payment were made by the central government and 10% was being made, but then also nothing has happened. Now, in the irrigation department, there is this different which is there. I think you need to inquire and find out. They were in a particular scheme, and this scheme, when they were brought in, they were specifically mentioned that they would be getting the benefit as per the old pension scheme, and that is why the irrigation department has been given out. If the state tomorrow says that, just for example, tomorrow the state says that no, irrespective. Forget about the NPS. I'll grant the OPS to everybody. Veterans, like in Himachal, they have done it.
Yes.
Veterans, then this court has no role out there. But when somebody wants the application of a particular law, the law has to be applied in that particular.
In Miller Rule 233 also, the power is available with the governor to relax these requirements.
Only 1 and 2.
Yes.
1 and 2, 3 cannot be. Now,
only 1 and 2 the government.
Now, if you see in one of the Supreme Court judgments, it is mentioned that these schemes are either floated by the at the behest of the central government or foreign agencies or so and so. But be that as it may, that does not say that these are service paid from the coffers of the government. That judgment is what one? You relied upon that judgment, you have forgotten. How can you forget that?
Colonel B.J. Akara. B.J. Akara.
No. B.J. Akara is a different one. B.J. Akara is the judgment where a person concerned, if direction is given and it is being implemented, then also the state can resist. That is DJ Akara, which has been taken followed in POP Nihwan. I'll give it to you. Wait, it is here. Dhyan Singh.
Here, my lord.
Anyways, Mr. Dutt, that was for a teacher's math. Let us open a Pandora's box for the DRD. Yes, you file your affidavit, huh? You should know. Heard Mr. S. Dr. Dalanit Counsel, Senior Counsel, assisted by Mr. D. Akayam, Mr. R. Pujari, Mr. N.K. Devnath appears on behalf of the respondent number 2, 3, 4. Mr. R.K. Talukdar appears for respondent number 6. Mr. R. Pujari appears for respondent number 5. Mr. H. Sharma appears for respondent number 1. And where is the Union of India?
7.
Lordship, I am for respondent number 7, Lord. CCC,
Yes,
Lord.
your name?
DJ Das, Lord.
Mr. DJ Das appears for the respondent number 7. Issue notice. When can you file your affidavit? Because this is a case where affidavits are required, not on the basis of instructions. Instructions I have already given you. To you. Yes.
4 weeks.
Yes. We'll have it on issue notice, making it returnable on 21st, on 28th of 20, June 2023. As the respondents are duly represented, extra copies of the writ petition be served upon them by 12th of May 2023. The claim of the petitioners herein is that they are entitled to the old pension scheme and not the new pension scheme as brought into effect by the office memorandum dated 6/10/2009. The respondents are directed to file their affidavit on 12th of June, on or before 12th of June 2023. The petitioner, if so advised, may file their reply by 19th of June 2023. But your problem arises with those two judgments, Parmeswarananda and Dhyan Singh.
Because Parmeswarananda is a fallout of Dhyan Singh. We will be relying on it.
5.
Mr. Datto, on the next occasion, if this court is sitting, come prepared. Because that is why I've asked them to file their affidavit by 12. If they file their affidavit, you file your reply, we can finish it.
Yes.
Because you are entitled or not in respect to pension matters needs to be early. Because if I keep this matter pending for years, at the end of the day, nothing is going to happen. Yes, Mr. S. Ali.
My lord, removal of secretary from the society matter.
Removal of the secretary of a society.
Yes, my lord. First of all, may I take your lordship to page 25, my lord?
Why this matter is before this court? Isn't this a bench 4 matter? Anyway, because I don't see Mr. S.K. Talukdar on the respondent side when I'm taking up this. He is always on this side, meaning therefore he is appearing for the corporation department. Anyways, tell me.
But kindly see, first I am removed. Thereafter, I am directed to submit show cause why I should not be removed. Kindly see.
So actually, it is a suspension.
As it appears, Lord, in fact,
Once you have already taken the action, where is the show cause notice?
no, in fact,
And is it required? Where is that order of removal?
Removal order. Government, there is no any government order.
You are the secretary of a cooperative
Yes,
society.
my lord.
Now, your appointment is made under Rule 41.
My lord, under 38(2).
38(2).
By the board.
এখন দেখুন cooperative society act.
So regarding removal, only government authority can do it. But here, the
Where is that order? In pursuance to the so and so, the function of the AI is hereby banned for the time being until further order. Where are you removed? You have been banned. Are you not referring to page 17? No.
no, my lord.
Which order you are referring to?
Page 25, my lord.
Page 25. No, 25 is a show cause.
So far. The impugn order, your lordship will find at page 44, my lord. In my
Page
mother perspective appointment.
44. This show cause is given on 25/1/2023. That therefore you are here when so and so of a meeting held that you are here. You are hereby, as per the resolution, that you are hereby removed from the post of the imam due to misappropriate the supply of so and so. Therefore, you are hereby directed to reply to the show cause as to why you would not be removed from the said post if any subject objection and written state within 7 days. A page
Now, my lord, kindly see, I am
Page
given 7
44.
days time. Page 44.
with reference to that, you are hereby informed that the appointment of so and so as the IC of the imam has been duly recorded and you may arrange for taking over the charge. So this is given to somebody else.
Somebody else. my lord.
Fantastic. Now, where is the impugn order? Page
This I have mainly impugned by this order as because in my place some other is appointed.
understood. So page 25.
Page 25.
So you were removed on the basis of a governing body resolution
Government good result.
of 25/1/2023.
No, my lord.
Yes, you mentioned, are you not Mukhtar Hussain? Yes, you are. It is hereby informed that as per the resolution number 1 of the meeting held on 25/1/2023, you are hereby removed from the post of so and so due to misappropriate the supply of PDS or TPDS commodity. Therefore, you are hereby asked directed to reply to the show cause as to why you would not be removed from the said post, if any. You see, it is actually the wrong English. It should be you have been for the time being.
That is why may I take your lordship to page 32, my lord. This is the subsequent resolution by which I am finally removed.
Okay. 32.
Page 32. Vernacular.
That is in Assamese.
In Assamese.
Why should I read that Assamese? Or is it the English is the same?
English
like the show cause notice in the translated form. Okay, then show me.
Yes.
Let us read page 29. 29 is the translated.
Yes, my lord. First resolution, page 30, may kindly be seen.
Page 30.
Yes.
Yes.
In today's meeting, it is held that as per the third resolution of the executive meeting of the Board of Directors dated 25/1/2023, although Mukhtar Hussain, the removed secretary of Uttar Bogoribari Samabay Committee, was directed to submit show cause within 7 days as to why he should not be removed. But since the Board of Directors still now have not received any kind of clarification from him, hence in today's meeting, Matiur Rahman, the honorable.
Now, is this let us read paragraph, the Pratham resolution in Assamese. Is it in Assamese or what? Yes, Assamese.
In Assamese.
Read it, page 32.
Page 32, my lord.
What do they say?
First resolution. আজির হবাত উত্তর বগুড়িবাড়ি সমবায় সমিতির বরখাস্ত হওয়া সম্পাদক মুখতার হুসেইনক 25/1/2023 ইংৰাজী তাৰিখত অনুষ্ঠিত হোৱা সঞ্চালক মণ্ডলীৰ কাৰ্যকৰী সভাৰ তৃতীয় প্ৰস্তাৱ মৰ্মে তেওঁক কিয় বৰখাস্ত কৰা নহব তাৰ বাবে তেওঁক 7 দিনৰ ভিতৰত উত্তৰ বিচাৰি জাননী প্ৰেৰণ কৰা হৈছিল। যদিও
No. Again read it. তেওঁক কিয় বৰখাস্ত
কৰা নহব
means that was the show cause.
Yes.
Why you should not be terminated. Yeah. Then, but as he has not replied, so you
বৰ্তমানলৈকে তেওঁৰ পৰা কোনো ধৰণৰ উত্তৰ বা স্পষ্টীকৰণ সঞ্চালক মণ্ডলীয়ে নোপোৱাত আজিৰ সদনত পুনৰ চূড়ান্তভাৱে বৰখাস্ত কৰাৰ বাবে সঞ্চালক মণ্ডলীৰ মাননীয় সদস্য
মতিউৰ ৰহমানে প্ৰস্তাৱত কৰাই আৰু মুলায়ম খানে সমৰ্থন কৰাৰ লগে লগে সঞ্চালক মণ্ডলীয়ে সমূহ সদস্য উক্ত প্ৰস্তাৱটো গৃহীত কৰিছে।
So the word used out there in the resolution is why he should not be terminated or discharged.
Yeah.
Why we use the word remove here? What is this remove business? Isn't it the proper word would be terminated? There's a difference between a removal and a termination. Okay, then let us see. You must have done so being influenced by page 25.
Page 25, my lord.
Yeah.
I am given 7 days time. Thereafter, kindly see, my lord, the notice was issued by post, my lord. Your lordship will find at page 27, my lord, on 27/1/2020. And the same was delivered to me, your lordship will find at page 28, my lord, on 3/2/2023, my lord.
Page?
Page 28, my lord.
28.
Serial number 10.
This 25 one is sent on?
27/1.
Okay. 27/1.
And this is delivered upon me on 23/2/2023, my lord.
Page?
Page 28.
Which one? 3/2/2023.
Yes, my lord.
And this was taken on 2/2.
2/2.
So therefore you want this to be set aside.
Yes, my lord. The ultimatum will end on 10/2. Prior to that, they have taken decision, my lord.
And what is this impugn order of 24/4?
This is the order of another person's appointment is recorded by the government authority in my.
That person has been only given in charge secretary.
Yes, my lord.
So in charge secretary is okay. But as of now, if this court is to set aside this, isn't it required to make whom should be made the party? The order has to be passed against whom? The president, chairman of Uttar. They have done it.
Yes.
Now, can this court do set aside unless anybody is representing them?
I have made him party.
I know that. But today, I can't do that.
Yes, my lord. Today it cannot be set aside.
But can I state now what will happen to the office of the secretary? Somebody has to work. All the PDS, everything, the secretary has to sign. So you better do one thing, take the results. And we'll take it up and set aside. But as of now, I can't. I would have otherwise set aside if this response number 5 was not there. What do you say, Mr. Talukdar?
That's correct. Lord, can I submit one aspect of the matter?
Please do.
Lord, in fact, there is a, my lord, remedy, my lord, there is a remedy, not under the act. There is a provision for statutory appeal. And your lordship is aware, since the resolution is taken by the board, it's a private entity. Perhaps against that resolution, writ petition may not be maintainable. There are some other judgments also. But since, my lord, there is a an order passed by the departmental officer at page 44, my lord, against this, my lord, writ is maintainable. But there is already a remedy under, my lord, 111. So, my lord, I think
111 is there, but the fact remains out here that this person concerned to be a secretary, it requires the recognition of that by a statutory authority. A person may be a secretary, but he has to be recognized also by a statutory authority. And the statutory authority have all along recognized it. And thereupon, this person concerned has been terminated, no problem. He has been terminated, but the termination also after that, a person concerned has been appointed as an in charge again by a statutory authority.
correct.
So under such circumstances, don't you think, as in the words of Mr. D.K. Das, advocate, a horizontal maintainability of the writ petition would not be there?
No, correct. Well, for the time being, my lord, this is maintainable. But certain documents are not annexed, my lord. I have instructions also because my lord, he has taken recourse to my lord
No,
certain
no, we will
irregularities.
issue notice.
Yes, yes.
I am not disposing it of. As
Deputy
I
Commissioner had
told
my lord,
you.
suspended the license and it was tagged with some other due to my lord the misdeeds. Man. These are
No,
not
no,
been-
that obviously, no, you have a right.
Yes.
That is why I'm not staying there, because the
Correct.
staying it would have,
Yes,
I'm
Lordship.
not also going to stay there in any order to do it.
Correct.
Heard Mr. A.S. Halim, the learned counsel for the petitioner. Mr. S.K. Talukdar appears on behalf of the
1 to 3,
respondent
madam.
number 1, 2, 3, and 5. 1, 2, 3?
1 to 3 only, my lord.
1, 2, 3, Mr. A. Chakraborty appears for the respondent number 4. Why are you making number 6 unnecessarily? His right is of an in charge right. As of now, as there is no secretary, therefore he has now been made a secretary. You want to make him, it's okay.
Charge is also not handed over. Charge is also not handed over.
Charge not given.
No much. That is why I am.
You are still holding the charge.
No, no,
Yes,
that
my
cannot. Resolution is of my lord, February, March.
Hard, yeah. So issue notice making it returnable on when? 31st. You can date it. Today is how much? Today is 11th. 20 days, enough? 10 days, huh? 20, 21 days. It's 3 weeks. Issue notice making it returnable by 31st of May 2023. As the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served during the course of the day. In respect to the respondent number 5 and 6, steps be taken by way of registered as well as usual by 12th of May 2023. The petitioner is further directed. You want an early disposal?
Yes, sir.
Directed to take steps by way of dusty upon the respondent number 5 and 6 routed through the registry of port and file an affidavit of service on or before the next date. The case of the petitioner herein, in brief, is that the petitioner has been terminated from the post of the secretary of the respondent number 5 committee, cooperative society, without following the principles of natural justice. The learned counsel appearing on behalf of the petitioner had drawn the attention to the communication dated, the show cause notice dated 25/1/2023, which had been enclosed as Annex 4 to the writ petition. Reference was drawn to the attention of this court was drawn to Annexure 5, which would show that the said document was, said show cause notice was sent by way of speed post on 27/1/2023. And Annexure 6, which would show that the said document was received by the petitioner on 3/2/2023. It is the further case of the petitioner by drawing reference to the resolution taken by the resolution taken in the executive meeting of the board of directors dated 2/2/2023, that is 1 day before the date on which the petitioner received the show cause notice, whereby the petitioner was terminated on the ground of not furnishing a reply. It is therefore the case of the petitioner herein that the said termination of the petitioner is violative of Article 14 of the Constitution. The respondent shall obtain instructions in that regard and apprise this court as to why the impugned order of the resolution by which the petitioner was terminated, dated 2/2/2023, 2/3 or 2/2? 2/2/2023, should not be set aside.
My lord, the termination is also in violation of section 38, clause 2.
The learned counsel appearing, paragraph to the learned counsel for the petitioner appearing on behalf of the petition further had submitted that the termination of the petitioner from the post of the secretary is also contrary to the provisions of the Assam Cooperative Societies Act 2007 and more particularly section
Subsection 2 of section 38.
section 38(2) of the same act.
I am obliged.
6.
Yes.
The petitioner was initially appointed as Deepika Shakti in the year.
You were terminated, suspended.
Your lordship, temporarily suspended at 12 year lordship.
What is this business of temporarily suspended?
I don't know, lordship.
Huh?
Has been temporarily suspended from her post.
Should not be issued to set aside and quash the suspension of the petitioner and issue a mandamus should not be issued directing and commanding to allow the after so and so. Yes, when were you suspended?
Page 12, your lordship, 14/9/2020.
Field inquiry so and so, has been so and so, and found that so and so with the help of
financial illegal.
financial entity of so and so and so and so so and so. Yes, where is the order of suspension?
This is the suspension order. This is the
Has been done in so and based on the complaint has been given by so and have found that so with the help of so and so in this connection has been temporarily suspended from her works and directed to repayment of so and so. Then
thereafter, lordship, page 13. The
Yes.
suspension has been withdrawn, conditional withdrawal.
what is this conditional word withdrawal? I direct you to return the same
He has been
to
allowed
so and
for
so on or before Iman, otherwise it will be considered as a criminal crime. Then
then a showcase notice was issued.
if your husband is involved in involvement of your work, misbehave with so and so, you will be terminated from yourself without any intimation. Then
Thereafter,
cause
then
has been
showcase
given.
notice issued by the state mission director.
Then you have given a reply.
Reply has been submitted.
Then
Page 15, your lordship. After
therefore withdrawal of my suspension. You are still under suspension.
still under suspension.
Then
No communication has been communicated to the petitioner whether he has been suspended or terminated till date after submitting the show cause reply. That means the page 13, the order is still in force, but I am barred to attend the office. I am verbally informed that I am suspended. This is the first I am temporarily suspended, then suspension has been withdrawn conditionally. Thereafter,
you were appointed as what?
Jivan Shakti, Deepika Shakti, your lord.
Huh?
Deepika Shakti,
What is that?
under State Rural Livelihood Mission, your lord.
No, what is that appointment? Jivika Sakhi. So you were suspended not under the provisions of the rules of 1960. You were, therefore, the question of subsistence allowance also is not there. Are you getting anything?
No.
Nothing.
Nothing.
Very well.
My
So
only
this suspension is just a suspension. Now you have been asked to do well. But then there was a show cause notice. You replied, nothing happened.
Nothing happened.
And you are from 2020, you are still for the last 3 years stagnated. Yes, Mr.
Order 9,
M.K.
10,
Devnath.
2020 is still in force.
Huh?
Order 9, 10, 2020 is still in force. Thereafter, no communication has been issued. Whether I am
Yes, what is this Jivika Sakti? What type of post is
Even
that?
I'm not aware of it. I'll need to check.
Huh?
Even I'm not aware of it.
Office of the Block Mission Management. Here is some DDU, GHI, what is this? Government of Assam, Assam Rural Livelihood Mission. Oh, these are mission.
Mission, your lord.
Okay, something like the health mission and all these things. Huh? Heard Mr. P. Rahman, the learned counsel appearing on behalf of the petitioner, Mr. N.K. Devnath appears on behalf of the respondent number 1,
And
2, 3, 4, and 5.
My
You're
lord,
paying for
1 and 4, madam.
RD is not under you.
No, madam.
State Mission Director, Assam State Rural Livelihood Mission. This is under whom?
That they are standing counsel for
Under PNR here.
Huh?
Under PNR.
I'm told that they are standing counsel, separate standing counsel for this.
Assam Rural Livelihood Mission.
Yes.
Oh. Then who is that? Who has informed you about such a valuable information?
I think sometimes ASLR, standing counsel ASLR.
Who? You are there?
No. I think the counsel is sometimes ASLR.
But you don't know.
I don't know the person. He told the counsel.
PNR.
Is there?
Only PNR here. My I-card has been issued by the PNR.
Then as he is not accepted in this one, and he is only accepting for 1 and 4, you have to take steps upon them. Or you want to inquire about this thing and serve a copy and come back, because unnecessarily this will be as on one date you on hand you are not getting a single penny for last so many years. What do you want?
I'll have the copy.
Understood, but I have to hold that nobody is appearing unless you are here. So let me take it up on to the Friday. You inquire and find out, and if necessary, you serve a copy. Huh? On Monday, we take it up. Because you have to serve and put a notice also, na? Then I'll mention that there is some counsel, you will inquire, and then if there is a counsel, you will submit. You'll hear copy, and the registry shall then list the matter on Monday.
Friday,
Friday, fantastic. But Friday it may not be possible anyway, because it will be difficult Friday, no? Because this needs to be done. Heard Mr. P. Rahman, the learned counsel, appearing on behalf of the petitioner. Mr. N.K. Devnath appears on behalf of the respondent number 1 to 4.
1 and
4. Mr. Devnath had submitted that he doesn't that the Assam State Rural Livelihood Mission has a standing counsel appointed in the High Court, as per his information. Taking into account that the instant petition has been moved without serving any copy upon the Assam State, upon the standing council of the Assam State Rural Livelihood Mission, the petitioner is directed to inquire, and thereupon, if there is any standing council, to serve a copy. To list the matter again on 31st, on 15th of May, 2020.
Hello.
Seven.
Yes, Mr. Bishop.
Here I am agreed by an staying order dated 12 April 2023, which has been passed.
You are aggrieved by?
An order dated 12 April 2023.
Where is it?
Page 35. Whereby the earlier order of transfer has been upheld by the authority. Earlier, I approached this honorable court by filing a writ petition. There was a direction to file a representation before the authority, mentioning about the grounds why I should not be transferred. I reiterated everything in the representation, but without considering all those aspects,
only consider the 1992 office memorandum and 2002 office memorandum, which says that before transferring a government servant who has not completed 3 years of service in a particular place of posting,
On receipt of the representation from the petitioner shall consider dispose of AR, and whereas the respondent so and so is also posted at so and so, where there is only one post of remark, whereas the compliance of the so and so modification of the official movement. Yes, what is your ground?
my ground that I would be retiring in the year 2023. I have been transferred now at a place which is 300 kilometers from my home address. My wife is also a government servant and working on the state government in the Department of Education. She is also posted in the same place, Karimganj, South Karimganj, and she would be retiring very soon, 2 months later. So I raised all these grievances before the authority, but the authority had only considered the office memorandum of 2013, whereby the 3 years period has been reduced to 2 years, because earlier there was a notification of 1992 and 2002 that if a government servant is sought to be transferred from a place of posting who has not completed 3 years, a chief minister's approval is necessary. Now that period of 3 years has been reduced to 2 years by a 2013 notification. I have no grievance for that. But my only grievance is that I have stated clearly everything in the representation. They have not considered anything. They have only said that there is a notification 2013 where chief ministerial approval is not necessary, and that's why I have been again transferred to Lamding.
No, show me where is the malafide.
There is no malafide, there is no arbitrariness, but when a representation is filed, my lord, it is to be disposed of. It cannot be a ground, my lord, that there is a notification.
No, first of all, you were lucky to get an order for disposal of a representation. What is your right out here?
But the representation
Is your service, conditions of service stipulate that it is a transferable job?
It's an incident of service.
Then
I agree,
happens.
but when a representation is to be, there is a direction to dispose of a representation. It cannot be reduced to an empty formality. There is a judgment of this honorable court, my lord. When a representation
You want this court should decide on the question of the representation being not decided properly. You want that? Okay, we'll issue this. But we will say that the transfer order shall be intact and you should act upon it. You're done?
my lord, I have certain difficulties, my
No,
lord.
no, that has to be done because if that is the reason why you are, we will take it up on an academic aspect as to how a representation is to be decided. We are not concerned to that effect. First of all, you have to show that, okay, whatever may be, a representation has been directed to be disposed of, given, and till then you were given us some protection out there. You were good enough, you got that protection now. Now, what else is the reason why you should be allowed to stay there?
Because there was a direction, because I mentioned the grounds in the earlier petition. Out of that, my lord, that finding came out that you approach the authority, file this representation, raise all these grievances before the authority. I raised all these grievances. There was not a single whisper about
But Mr. Biswas, you have to appreciate one thing, that the power under 226 is very limited in the transfer matter.
Yes, I agree.
Then why?
But when there is a representation to be submitted, when the grounds are stated in the representation clearly, it is the bounden duty of the authority to deal with those.
Okay, let us assume that the authority did not do it. Fantastic. But does it give you a right to remain in the same post? No.
I have been there out of this court order, so there was a stay.
No, does it give you a right now?
Per se, there is no right, but when a representation, I was directed to file a representation stating all the grounds.
There are many Supreme Court judgments wherein it says that you have to go and join there and thereafter submit your representation. Have you joined there?
No, madam, because
You want that I can apply that law for you,
there was a
for your
stay,
benefit?
there was a stay order.
Again, submit another representation.
There was a stay order operating in my favor until the stay order was passed, madam.
No, nothing doing. This court doesn't see. You have to show me. That cannot be a ground that the representation has not been properly disposed of. That is absolutely within their domain. The reason why the representation is done, because this court doesn't want to do it, so that a considerate position may be taken by the authorities concerned for that, which this court, as under 226 you cannot do because it is a very limited jurisdiction under transfer.
That direction gave an expectation, my lord, gave rise to an expectation a common citizen when comes to a court, my lord, and when the authority is doing nothing.
First of all, your petition should be dismissed on that day itself. The earlier judge was kind enough,
Luckily,
which however I am not.
Your lordship would be kind enough relying on the judgment of 2008 passed by Honorable Justice Mr. Goswami, where the representation when they filed by a citizen, it should be disposed of. It cannot be reduced to an empty formality only because we have nothing, my lord. We are before this court.
No. Therefore, yes, no quarrel. A representation when sent has to be disposed of in a manner which is permissible under law. Now the question is, if it is not done, does it give you a right to remain in the post? That is the question which I am on. I am not on the others. Very well, representation is there. But because you have to appreciate one thing, this court does not create any rights on it. No. The court has only said that the representation will be taken into consideration, that you submit a representation, they will do it. This is only in some courts, they do it for the purpose that instead of dismissing it on your case, they do it like that. And you will submit a representation, you go there. But why should this court think? I am not such a considerate person for that purpose.
But this court obviously looks into the convenience of a citizen, my lord.
That day I rightly said to somebody, these are matters to be actually decided, looked into by the division bench. I dismiss it to go to the division bench.
Before that, if I may rely on a judgment.
What?
How representation should be dealt with, my lord, by the authority.
Fantastic. You give it to me.
Otherwise,
I'll also rely upon two other judgments of the Supreme Court on the transfer, that it cannot be touched upon.
I am not wholly on the transfer, but
You are on the question of transfer. Why? First and foremost, you on the basis that the representation has not been properly disposed of, do you get a right on the basis thereof to remain in service when the transfer has been made in the exigency of service?
But besides coming before this court, there is no other forum available for a
Don't
common
come.
citizen.
That is why the Supreme Court has said, go and submit, first join there, submit a representation, then you come. If the representation is there, then a considered view will be taken as regards the administrative. Because therefore, in a transfer matter, the scope of jurisdiction under 226 is very limited. And this is the limited scope. Why should they? That is why I asked you, is there a case of malafide? No.
But the way they dispose of the representation shows the arbitrariness on the part of the respondent authorities. And if
For what arbitrariness? Arbitrariness has not to be seen on the basis of what are the grounds you are taken and the reasons is been given in that. Because you cannot equate a reasonable order in the sense of a order being passed by a judicial authority or even a quasi-judicial authority. This is an administrative order. You can't expect that an administrative person will have to pass. Then why not appoint some AGS officials out there for the purpose of consideration of the representations? The government and the finance department can obtain a sanction for that. Why not? Isn't it, Mr. Barpuzai? If the representations are to be disposed of in the manner of a judgment of a court, there has to be an official out there in every department who has the legal acumen for the purpose of disposing of the representations. Isn't it so? And for that, your permission will be required, finance.
But that's why the post holders are IS and ACS.
IS and IBS are good only for the purpose of the administration. That is why it is known as the Indian Administrative Service. It doesn't mention that it is as Indian Judicial Service. Administration is an administrative order. Like in many cases, if you see, even in the income tax matter, an order which is being passed for the purpose of going for a search is an order which is an administrative order. It cannot be equated with a judicial or a quasi-judicial, and for which you require the same reasons for that. Yes, a representation has been directed to be submitted. Yes, they will look into it. if we are going to look into those aspects of the matter, that this representation has to be taken into account as an appellate authority. What is left?
It is the expectation of everyone. The grounds taken in the representation could be considered by the authority. Yes or no, it's their prerogative. I have no objection. But when the grounds are stated,
Whether it is taken into consideration or not, is it required to be reflected in the order? Tell me.
yes, my lord, because these are the grounds, main grounds on which I filed the earlier writ petition. And when a common citizen comes before this court with an expectation that something would be done on behalf of the authority, it is to be done, my lord, with equity. There is no scope, my lord, for arbitrariness or malafidence. I am not alleging arbitrariness or malafidence, but on the contents of the representation I filed, the grounds taken here, this is, I am going to return the next year. My wife is going to return the few months later. And I have been posted at a place which is 300 kilometers away. What would the citizen do if nothing has come up from the authority? It is for the court, my lord, the constitutional court. There is no other forum available. Had there been other forum, I would have approached there, my lord. But unfortunately, there is no other forum under the Constitution of India.
Therefore, you have to. Therefore, forget about without the representation. Do you have a case? If you don't have a case, then why should this court interfere under 226 on the ground that the representation has not been disposed of with the reasons which is required to be given in terms with this court, which this court feels that the reasons should be in this
Since my
manner?
earlier petition was not disposed of, dismissed, and I was directed to file a representation, I was on a bona fide belief that my representation would be considered, and ground would be considered at least. But there is nothing. There is only a mention of memorandum of 1992, 2002, and the subsequent memorandum of 2013, by which the earlier.
Now, did you say? Are you saying that that order, which was being passed by Justice Zameen, was an order passed on consensus? Or was it a direction passed, not a consensus order?
It was a direction first.
No, yes.
To file a representation.
Yes. Was it consensus?
But they did not object to
No, no, no. Was it consensus?
I was not present, so I cannot comment.
No, no. If it is not a consensus, then it is a direction. The court found it prudent enough that you go before the authority and submit a representation and gave you a limited protection. That's all. But if it is a consensus, then also you have agreed to go there. What can be done? And the court was much kind enough, okay, to not to disturb you for the time being.
Well, the court is always kind enough to citizens.
I am not kind for that purpose.
The Lordship is rising.
I'll rise and pass the. Just think about now to withdraw or dismiss.
As far as practicable, in the same place or nearby place has been recognized. The 2008 judgment, I'm relying on the last paragraph, paragraph 16.
Which one?
2008 3 JLR 628. The last paragraph, paragraph 16. As per the policy guidelines of the state government, the husband and wife are required to be posted at the same place of posting as far as practicable. In the matter of transfer and posting, the ministerial intervention is not necessary, but this line, there are some guidelines which says that as far as practicable, or if it's possible, not in the same, even if not in the same place, nearby places. There are other places also nearby Karimganj where 3 number of posts are vacant. They may consider. I have given so much to the department. This is the last service of 1.5 years has left in my service life.
Then
2018 Port GLT. I'm basically relying on paragraph 28. When a representation is directed to be disposed of by the court, the disposal of the representation cannot be reduced an empty formality. In the instant case, the grounds taken in the representation by the petitioner was not even dealt with. A public order publicly made has to be read as it is, and reasons cannot be supplemented by of an affidavit later on. The observation made in the order that so and so that the chief minister subsequently approved the order of transfer is also not found. But there are other vacant posts nearby Karimganj, district of Karimganj.
so you said submit it in your representation.
Yes.
That there are other vacant posts. Why haven't you done
Lord,
that?
I have raised pertinent questions and the statements that I am going to
Mr.
detail.
Biswas, tell me why you were asked to file the representation?
First, I court thought it proper to the authority to decide where I should be posted.
Huh?
Or the grounds taken in the writ petition, it is for the authority to decide. And the grounds which I have mentioned in the representation, it is also for the authority to decide. A person, when goes to an authority with an expectation that my grievances would be taken care of, if it is not taken care of, then the last resort is before this court.
I'm not on that. I'm asking you, why have you been asked to submit a representation?
Perhaps the honorable court was of the opinion that it is for the department to decide.
Is it?
If I may take your honor to the order dated 30/11/2022, page 30.
Have you read it?
I am reading, madam.
Or you are reading it at the now?
If I may, madam.
No. Have you read that order before making that submission?
Yes, I.
Fantastic. Why were you asked to file the representation?
Because I mentioned about some notifications from 1992 and 2002, which has now been overturned by an earlier notification of 2013.
Then?
And one more ground, the other ground is that petitioner will be retiring on 30/11/2024, and therefore the back end of his career, he may not be transferred at a place which is 300 kilometers from his present place of posting. I have no objection if I am posted any place nearby. There are other posts vacant.
Okay, let me dictate the order, then you may know the reason why you were asked.
If your lordship is
Heard
dismissing it, I may
Mr.
be
S.
given-
Biswas, the learned counsel appearing on behalf of the petitioner. Mr. N.K. Devnath appears for the Panchayat and Rural Development Department. Mr. C.S. Hazarika appears for the Deputy Commissioner, Karimganj. Why are you making the respondent number 6 a party?
Well, he has been posted now in my place here. I am also there. He is also here. So I thought there would be, if any implications come on his.
The
posting.
instant repetition for the purpose for the order which this court proposes this to pass at this motion stage, this court does not deem the presence of the respondent number 6 is necessary. Next. The instant repetition is taken up for disposal at the motion stage itself. A perusal of the materials on record reveals that while an order dated 5th of November 2022, the petitioner was transferred and posted at Lamding Development Block under Hojai District. From the post of the Assistant Account Officer of South Karimganj District. This order was put to challenge before this court in WPC number 7685/2022. This court, by the order dated 30/11/2022, had disposed of the said writ petition. It appears from the order dated 30/11/2022 that the petitioner had raised two issues, thereby challenging the transfer order dated 5/11/2022. The first reason which was assigned was that the petitioner was yet to complete 2 years in his place of posting. The second reason was that the petitioner was retiring on 30/11/2024, and therefore at the fag end of his career, hardship would be caused to him if he is transferred to the place 300 kilometers away from South Karimganj development block. Further to that, the case of the petitioner is that his spouse was serving in Kachar district. This court, after duly taking note of the fact that the petitioner approached this court by filing a writ petition challenging the order dated 5/11/2022 without submitting a representation, had therefore directed the petitioner to make a representation before the respondent number 2 within a period of 1 week from the date of the said order. And the respondent number 2 was directed on receipt of the said representation to consider and dispose of the same by a speaking order in accordance with law, and also by taking into account the office memorandum dated 19/9/92 and 22/5/2002. It was also directed that the said representation be disposed of within a period of 3 weeks from the date of the receipt of the representation, until such time the transfer order dated 5/11/2022 shall remain suspended. It further reveals on record that on 6/12/2022, that is, even after a period of 1 month, on 6/12/2022, the petitioner submitted a representation to the Commissioner Panchayat and Rural Development Department, the Development Department of the Government of Assam. Subsequent thereto, on 12th of April 2023, the said representation was disposed of, and taking into account that the office memorandum dated 19/9/92 and 22/5/2002 was modified, whereby the period of 3 years which were mentioned was reduced to 2 years. And further taking into account that the petitioner joined as an assistant accounts officer in the South Karimganj development block on 22/6/2020, and the transfer order was issued on 5/11/2022, which is after the completion of 2 years, directed the petitioner to report as per the transfer order dated 5/11/2022. This order dated 12th of April 2023 has been put to challenge by way of the instant writ petition. I've heard the learned counsels for the parties. The learned counsel, Mr. S. Biswas, duly submitted that the representation which was submitted by the petitioner contained various grounds However, it was only on the ground that the petitioner, having completed more than 2 years in that particular post, the representation so submitted by the petitioner was rejected. He submitted that although in a office memorandum of the government of Assam, it has been mentioned that as far as practicable, the officer and his spouse, if working in the same practicable. That although the government servants are allowed to stay at their home station on the eve of their retirement, and such policy and procedure is followed on sound principles, that the posting of the government servant at his home station in the last years of the service allows setting in his life on his retirement smoothly. But the respondent authorities did not take into consider the said aspect of the matter. He further submitted that the wife of the petitioner, who is also serving in the Kachar district, needs constant medical support as is suffering from serious hypertension and serious stomach problems. And the petitioner's son is a student who is pursuing his studies at NIT Silchar, staying at the hostel. The learned counsel for the petitioner further submitted by drawing reference to an judgment passed by a coordinate bench in the case of Makibar Rahman versus the state of Assam and others, reported in 2018 4 GLT 78, wherein it has been mentioned that when a representation is to be disposed of, is directed to be disposed of, such representation, such direction should not be reduced to an empty formality. Further reference has been drawn to the judgment of another judgment of this court in the case of Pallavi Chaudhary versus state of Assam and others, reported in 2008 3 JLR 628. Wherein there is a reference that as per the policy guidelines of the state of government, the husband and the wife are required to be posted at the same place of posting as far as practicable. I have perused the materials on record and have also gone through the judgments which have been placed by the learned counsel appearing on behalf of the petitioner. Before further dealing with those two judgments, this court finds it relevant to refer to a judgment of the Supreme Court in the case of Public Service Tribunal Bar Association versus the state of UP and others, reported in 2003 4 SCC 104, wherein the Supreme Court laid down the scope of judicial review in matters pertaining to transfer. Paragraph 37 of the said judgment. In paragraph 37 of the said judgment, the Supreme Court held, after taking into account the Supreme Court held that transfer is an incident of service and is made in administrative exigencies. Normally, it is not to be interfered with by the court, and it has been the consistent view that orders of transfer should not be interfered with except in rare cases where the transfer has been made in a vindictive manner. The above will therefore show that the power to be exercised under Article 226 in respect to the transfer, is limited and circumscribed. Now coming to the judgments which have been referred to by the learned counsel appearing on behalf of the petitioner. It would be seen that the facts involved therein are completely different and distinct from the facts involved here in the instant proceedings. In a recent judgment of the Supreme Court in the case of Kotak Mahindra versus so-and-so, reported in 2022, 9 SCC page so-and-so, the Supreme Court had categorically observed at paragraph number 64 of the said judgment that an additional fact can make a whole world of a difference in applying a ratio in respect to a similarly situated case. In the judgments which have been referred to by the learned counsel appearing on behalf of the petitioners, as the facts therein were different and distinct from the facts involved in the instant proceedings, the law as laid down therein cannot be squarely made applicable to the present case. Taking into account the same, this court is not inclined to interfere with the order dated 5/11/2022, or for that matter, the order dated 23/12/2023. However, before parting with the record, this court finds it relevant to take into consideration the submission made by the learned counsel for the petitioner that in the nearby district in Karimganj, there are 3 other posts, vacant posts, and the petitioner is to retire on 30/11/2024. And as such, the responding authorities can consider the case of the petitioner for transferring him to a post in a nearby district, then to transfer him to a location which is 300 kilometers away from the present place of posting of the petitioner. This court, after giving anxious consideration to the matter, gives the liberty to the petitioner upon joining his place of posting in terms with the transfer order dated 5/11/2022 to submit a representation to the Commissioner, Panchayat and Rural Development Department, taking into account that the petitioner is going to retire on 30/11/2024. And the Commissioner, Panchayat and Rural Development Department is requested to consider the representation of the petitioner and, if possible, to bring him within to a nearby district so that the petitioner can spend his last year of service with his family.
Much obliged.
If this order was passed then, you could have got it. Instead of these 2 years. It
Before your lordship, she is a widow, my lord, and her son was died on 26/10/2018. He was an associate professor of the college, Borbata Girls College, my lord. Now, my lord, pension has been, my lord, the name of my lord wife. And my lord, I made a petition before the appropriate authority. Disburse, my lord, my part, my lord. Because after
your son was working as
associate professor of Borbata Girls College.
Borpeta Girls College. Okay, then he died in harness.
Died in harness.
When?
On 26/10/2018.
So you are entitled to the family pension?
Family pension, and now, my lord, my daughter-in-law, she left me, my lord, and she is living separately and not.
No, are you entitled to the compassionate family pension?
Your lordship kindly see.
When was your son supposed to retire?
Son supposed to retire, my lord. Yes. Workman. Let me. Workman.
Yes.
Page 9, my lord. Your lordship.
Page? Oh,
I'm
Mr.
sorry,
Mohanto,
yes.
you have not been briefed well. Yeah, Mr. Islam, you have not briefed him well. Huh? I don't know, this is the most.
Near about, my lord, 10 years I have to service, my lord.
Huh?
I didn't harness, probably he's.
I'm withdrawing the said amount on a man.
Probably at the time of death, my lord, he was 52 years. 52 years.
Then how do you say that? Because then it is a case of compassionate family pension.
Yes, my lord.
If it is a case of compassionate family pension, then you are entitled under 5.10 to
Yes,
approach the authority.
Yes.
And the authority, if it does not do so.
5.10. Yes,
Huh?
that's why I opposed the authority.
But how do I know
So I
that he has years of service?
No, my lord, already that The pension has been sanctioned to the wife, my lord, that compensation, the pension, my lord.
Is it so?
Yes, my lord.
Where is it?
That is
Show me that.
sanctioned, my lord.
Because his right only will be there till that, only till he
Yes,
retires.
yes, exactly, my lord.
Then,
Page 35, Annex 8, my lord.
Hmm. What is this judgment? Oh, this one.
My lord.
Oh, you withdrew the,
My lord.
and now you are filing this.
No, my lord, I oppose my lord authority because already it is now, my lord, area, everything has been sanctioned to it is lying in the treasury office, my lord. If it is disbursed, she has, my lord, taken him, then again I go for a suit, my lord. If she taken
No,
now,
no, did you approach them?
yes, my lord, that is, my lord.
Where?
Here, page, my lord. Yes, page 40, my lord. On 12/4/2020.
Page 40.
40, my lord.
Therefore, I earnestly request you kindly to admit this application and take necessary steps to release the share of monthly family pension as per so and so. Government has released an amount of 35 lakhs as area family pension for the period from so and so to so and so. And the same is lying pending in the office of the Treasury, Kolkata. When was he supposed to retire? You mentioned that, na?
Yes, that could have been mentioned, my lord. That is,
After coming for the second round of litigation also, you don't know that. Why have you approached under 5.10 unless he gets it? Because if any order is passed and it is not a case of family pension, then a compassionate family pension, then you don't have a right. Unless note 2 of D is read in your favor.
exactly, my lord. That is the
For that, for me to have to win the election. Yes.
I will take the instruction. That is the
Huh?
It will be happened.
By way of an affidavit, additional affidavit.
My lord.
Monday, Mr. T.J. Mohanto, the learned senior counsel, assisted by S. Islam, whose request for an accommodation for bringing on record by filing an additional affidavit, the date of retirement of the son of the petitioner, who is permitted to do so. List the matter again on 15/5/2023.
My lord.
9.
May I please your lordship? Lordship, I am appearing on behalf of SP Das. He could not appear today due to his illness. Lordship.
May I please, the matter pertains to non-payment of family pension.
Pay the family pension and area family pension as per the retirement benefits payable to the petitioner against the service rendered by her deceased husband forfeit. Oh, yes, tell me.
My lord.
It looks unfortunate. You have not got something.
Yes, my lord.
Why?
My lord, what is happened, my lord? My husband is while working as an assistant employment officer, my lord, in the test school. My lord, he was
Your
suspended.
husband was a lower division assistant
Initially,
under
he was-
so and so, respondent authority. What is this respondent authority?
My lord, labor and employment
Which
department.
authority?
Labor and employment department, my lord.
Mr. Counsel, which authority?
Labor department, my lord.
Labor Department.
Yes.
So there you are the lower division assistant.
Initially appointed.
Then
I am promoted to my lord, assistant employment officer, my lord. While I am working in my lord test school, my lord, I was suspended on my lord 2009, my lord, from service, my lord. Thereafter, my lord, I retired from service.
so you retired.
Yes, my lord. Thereafter, I died.
and the suspension order was not reviewed or revoked.
Yes, my lord.
And the suspension happened on 3/8/2009.
Yes, my lord. Yeah.
And you joined on 18/12/1976.
Yes, my lord.
So 9 plus another 24 years would be 33 years. 33 years. And you retired on 2011.
Yes, my lord. Thereafter, my lord, I died, my lord, 2014. my lord.
You died?
No, my lord. My husband died, my lord.
Then
my lord, I have applied, my lord. They have processed, my lord. My lord, kindly come to the page number 25, my lord. Page number 25, type for me, my lord. Initially, my lord, provisional family pension sanction, my lord, for 1 year, my lord. Thereafter, again, stop, my lord. Thereafter,
so you got the provisional family pension
Oh, only for 1 year.
from
After
2016
no, my lord, 2014, my lord, 24/9/2014.
with effect from so and so.
Thereafter,
Okay,
my
then
lord, my lord, stop, my lord.
it stopped.
Yes, my lord.
So you are without a pension, family pension since then.
My lord, thereafter, I approached to the authority, my lord. They have again, my lord, page number 30, my lord.
Ah,
Page number 30. Now they have sanctioned for 2 years, my lord, with effect from 24/9/2015, my lord. Thereafter, again, stop, my lord, after 2 years, my lord. I have approached. Thereafter, I again stop,
so last pension you have got till when?
till my lord 2017, my lord.
Till 2017 you have got it.
Yes, my lord.
Okay, so we are not worried till then.
My lord.
Till 2017.
Yes.
What is the date?
My lord, 24/9/2017, my lord.
Ah,
Last, my lord, I have proved, my lord. Thereafter, my lord,
22.
24/9/2017, my lord.
You have got it.
Yes, my lord.
24/9/2017.
Yes, my lord.
And thereafter you have not got it.
Not gotten, my lord. Thereafter, I approached to the authority, my lord, by filing representation, my lord, page number 33, 30, 34.
It's okay. Heard Mr.
D. Google, my lord.
D. Gogoi, the learned counsel for the petitioner. Now, this time the list of dates is better.
Yes, my lord. I tried it.
Although this is not that matter.
Not a matter. Supplementary.
You are the counsel on the last occasion, no?
Yes, my lord.
To whom I said you have to be improve yourself. Who is labor? Mr. Dibora?
Yes.
Mr. Dibora, IPS.
1 and 2.
Respondent number 1 and 2. And 3 and 4, who is appearing?
SP Das, the name of SP Das,
Who?
SP Das, he's standing counsel for Director of Employment and Craftsman Training.
And then what should I do?
He's for respondent 3 and 4.
But he is not here. I don't recognize him, but if you recognize him, is he here?
Lordship, I am appearing on behalf of him.
So what is your name?
A. Along.
Yeah. A. Alam appears on behalf of respondent number 3 and 4. Mr. A. Hassan appears for respondent number 5. The case of the petitioner, issue notice making it returnable. Who is the person who has done all these things? Why he has not got you are? No, why the final pension has not happened?
That I have to take instructions.
Now, first of all, what 2011 is the case where the person has retired. And till now, if it takes another 12 years for the purpose of finalizing, then why interest should not be imposed? That also instructions you take it. And they also not required officially, but unofficially you also ask them the names of the officials whose names have to be put out there. No? Against whose aiding salary has to be counted. Yes. Heard Mr. So-and-so and so-and-so. The case of the petitioner hearing is that the husband of the petitioner was appointed as a lower divisional assistant, LDA, on 18/12/1976. The petitioner, the husband of the petitioner thereupon rendered his service. However, on 3/8/2009, the husband of the petitioner was suspended pending drawal of departmental proceedings. However, the petitioner is not aware as to whether any departmental proceedings were initiated. Be that as it may, the husband of the petitioner attained his age of superannuation till the retirement of the husband of the petitioner on 28/2/2011. Unfortunately, the husband of the petitioner expired on 23/9/2014 without receiving any pension or any other payable retirement benefits as per the Assam Service Bracket Pension Rules 1969. Subsequent thereto, the petitioner, after following it up with the respondent authorities, years together, were given the provisional pension up till when did last date? 17, you said some date.
24/9/2017.
24/9/2017. Thereafter, the petitioner have not received any family pension. It is the further case of the petitioner that the petitioners that the regular pension and other retirement benefits have also not been finalized by the respondent authorities till date. Has it been finalized?
Not much.
So being aggrieved, therefore, the petitioner is before this court. The learned counsel appearing on behalf of the, which department will be? You, Mr. On behalf of the respondent number 1 and 2. Shall apprise this court as to why the petitioner have not been given the family pension, provisional family pension pursuant to 24/9/2017. The said respondent shall also apprise this court as to what happened to as to whether the departmental proceedings was at all initiated, and if so, what has happened to the said departmental proceedings. Further to that, the learned counsel for the respondent number 1 and 2 shall also apprise this court as to whether the proposal for final pension and other pensionary benefits have been processed, have been sent to the office of the accountant general, that is the respondent number 5. The learned counsel appearing on behalf of the respondent number 5 shall also apprise this court on the next date as to whether any proposal has been sent from the respondent number 1 and 2 as regards the pension as well as the pensionary benefits of the husband of the petitioner and the family pension of the petitioner. Hey, issue notice returnable? No idea. Issue notice. When? 7th of June. Issue notice returnable. As so and so duly accepts notice, extra copies be served by. You serve it by today?
No.
Okay, by today, huh? Yeah. The petitioner is given the liberty to mention the matter for upgrading on the next slide.
Lordship, the name of SC Employment and Craftsman Trading may be reflected in the respondent side.
The registry shall also indicate the name of the SC Standing Council. What is that?
Employment and Craftsman Trading.
Employment and Craftsman Trading.
Hello.
Then yes.
Right, please, yes, your lordship. Lordship, the matter pertains to non-payment of retirement.
Oh, that matter?
No, this is another matter.
Another matter. I understand that is another matter, but it's not getting the same thing.
Yes, they retired on 2006.
Area and salary.
No, my lordship, it's about leave encashment gratuity, my lord.
Leave encashment you have not got. How much?
It's around, leave encashment is 5 lakhs, 8,200. 5 lakhs, 8,200.
5 lakh 8,200. Which include gratuity and leave encashment. Where is the details given in your petition?
Yes, it's
Page 7, madam.
page 7, para 6, my lord.
So you are entitled to gratuity of 5 lakh 8,200 and 7 lakhs for leave encashment.
Yes.
Heard, Mr.
P.S. Raja, my lordship.
So and so the PS
P.S.
Raja,
Yes, my lord.
the learned counsel appearing on behalf of the petitioner, Miss, madam, you are appearing for?
For respondent number 1, 3, 4, and 5.
Yes, on behalf of the respondent number 1, 3, 4, and 5. Mr. R. Bapujari appears for the respondent number 2. You should notice making it returnable. When, madam, we can get some instructions?
My lordship, my lord. Earlier, similar sets of petitions were disposed of in the motion day itself, my lordship. I have an order.
What?
Similar sets of petitions, my lordship.
No, my lord, I need instruction, my lord.
No. Let her, yes, well. I gave you a right of say, you say it. Now that is her turn. Yes, well.
My lord, within 3 weeks, my lord.
Fantastic. You get it, I'll give you more than that. On 12th of June?
Yes.
You should notice making it returnable on 12th of June. As the respondents are duly represented, extra copies of the petition be served upon the learned counsels representing the respondents by 12th of May 2023. The petitioner herein has filed the instant with petition being agreed by non-payment of the amount of rupees 5,08,200 on account of gratuity and rupees 7 lakh on account of the leave encashment by the respondent number 4 and 5. The learned counsel appearing on behalf of the respondent number 1, 3, 4, and 5 shall apprise this court on the next returnable date as to why and when the say amounts have not been paid and would be paid.
11.
G. Bora. Yes.
May it pleases your lordship. My lord, the case pertains to non-payment of pension. However, my lord, the set of facts which are culminated into this writ petition is this. The petitioner has been serving for last 35 years. He is as an associate professor in Assamese department in Nirmal Aloi College. Now, my lord, in the year 2018, the governing body imposed a penalty of 20,000 rupees on him on the ground that he was in charge principal for 2.5 months, and during that period he was in charge of the service record of the then principal, who is still the principal, and while returning the service record, some pages were missing. Be that as it may, my lord, that order of penalty were put to challenge before this Honorable High Court by means of a writ petition. When the matter came up at the motion stage, this Honorable Court has stayed that impugned order assailed in that case until further order. Now, my lord, during pendency of that writ petition, I retired on 31st of July 2022. Last year, 31st July, and that writ petition is 2021. Now, the principal of that college, I have made him a party by name. He's a party by name both in the earlier writ petition and even in that petition. The principal of the college, he is not processing my pension file. I have not received even 1 rupee pensionary benefit, not pension. He is saying that either you withdraw that, we are not, because it is sub judice. Now, my lord, how that is sub judice because of that case, how my pensionary benefit and pension, even provisional pension, final pension, nothing has been finalized. I am not the official respondent, the AG probably will, because the principal has not forwarded. This is my grievance.
So they are not in a position to do anything unless and until the principal forwards. So you're long and short. And the principal is not here.
Principal is here. He is here by post as well as by name.
4 and 5.
Absolutely.
3, 4, and 5. But who is going to pay you the provisional pension?
My lord, it will, because for the higher education, my lord, it is the governing body, they send the proposal to the AG. Is represented.
No, that is for final pension.
Final pension.
Provisional who
Provisional
gives?
pension also, my lord, probably AG.
No.
Then I'm not aware of.
They, you.
Yes, sir.
Why provisional pension you have not given? Is any departmental proceedings?
Nothing, my lord, that governing body which is stayed by this court.
Then why he is not entitled to the provisional pension? Mr. Mehdi, you have no role provisional.
Yes, yes.
You have?
No, no.
No, he doesn't have.
For that, my lord, I have to see inspection of the certificate, why provisional pension is not paid.
So we issue notice
Yes, yes.
only on 1, 2.
Principal is also required, my lord, because main grievance is against the principal for final. Accept.
Mr. M. Biswas, the learned counsel, appearing on behalf of the petitioner. Mr.
S. Das, ma'am.
S. Das appears on behalf of the respondent number 1 and 2. Mr. S.K. Mehdi appears for the respondent number 6. Issue notice making it returnable by 5th of today is no 10 ekma ho bole by 12th of June. As the respondent number 1, 2, and 6 are duly represented, extra copies of the writ petition be given by 12th of May. And full stop. As regards the respondent number 3, 4, and 5, the petitioner shall take steps by way of registered as well as usual. The petitioner is also directed to take steps by way of dusty, routed through the registry of this court, and file an affidavit of service insofar as the service upon the respondent number 3, 4, and 5 is concerned. The case of the petitioner herein is that the petitioner was appointed as a assistant professor. You are assistant professor?
Associate professor.
Associate professor in the Nirmal Haloi College, Patharkuchi. 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 During his service career, the respondent number 5, the respondent number 3 passed a resolution to impose a penalty of rupees 20,000, which was duly communicated to him by the respondent number 5. Being aggrieved, the petitioner challenged the said in WPC number 3143/2021, and this court by an order dated 15/7/2021 had issued notice and making it, and in the interim state the contents of the communication dated 27/11/2020. In the meantime, the petitioner retired on 31/7/2022. It is the case of the petitioners that in view of the pendency of the petition, that is WPC number 3143/2021, the respondent number 3, 4, and 5, and more particularly the respondent number 5, have not sent the proposal to the Office of the Accountant General for the purpose of processing the pension as well as the pensionary benefits of the petitioner, and as regards, and also to the Office of the Director of Higher Education for the purpose of a provisional pension. The learned counsel further referred to the Rule 22 of the Assam Service Rules 1969, as well as the Office Memorandum dated 21/6/2012, and submitted that immediately upon the retirement of the petitioner is entitled to the provisional pension as well as the DCRG. Taking into account the same, in the background, the petitioner being aggrieved with the actions of the respondents, therefore has approached this court. The petitioner, the respondent in the higher education department, the respondents number 1 and 2 are directed to apprise this court on the next returnable date as to why the provisional pension has not been paid in conformity with Rule 22 of the Rules of 1969, as well as the office memorandum dated 21 into Kurukshetra, Delhi. The respondent number 3, 4, and 5 shall also apprise this court as to whether the proposal for the pension and other pensionary benefits of the petitioner have been sent to the concerned authorities. Pendency of the pending notice, pending in the interim till the next date, it shall not be a bar upon the Director of Higher Education to process and pay the provisional pension to the petitioner. Liberty is given to the petitioner to mention the matter for argument.
I'm deeply offended.
Item 12.
Actually, my lord, another similar matter was listed before court number 5.
Okay.
We didn't know that, my lord, this particular electricity grid corporation also has a council. Now, of course, today I've given the copy, my lord.
Agreed.
Agreed.
Agreed. I think Mr. Monto
No,
represents something.
I think Escoto came.
Oh, you are there. Oh, yes, yes.
My lord, otherwise the issue is covered by judgment. My lord, friend may like to have the instruction.
Which one?
Yes, judgment is at page number 61, madam. The issue is whether I am entitled to the revised pension, madam. If you lordship could kindly come to page 61, last two, paragraph 20 towards the bottom. From a conjoint reading of the provisions of revised pay rule 27.
Page?
Page 61.
Oh, 61. Okay. That is pending appeal.
No, my lord, that appeal, no, an appeal was preferred against a similar order. There no interim order has been given.
No interim is given. Okay.
Of course,
Appeal
we have given
involves
an
an academic issue as to the actual date of retirement of the respondent, whether he would be retired on 31 or 1/4/2016, and his consequential entitlement to receive the benefits under 2017 rules. Okay, then.
Now, my lord, now appeal was admitted and we have been given the benefit given by the learned Singh. Coincidentally, we appeared in that case also, my lord. Now, otherwise, the single judge's judgment is at page 61, operative portion. Para 20, last two line. From a conjoint reading of the provisions of the revised pay rule 2017, more to particularly rule 1, 2, 4, 32, etc. Together with this court is of the unhesitant view that petitioner who was in service on 31/3/16 and who retired from the service on reaching the age of superannuation also on 31/3/16 cannot be categorized and bracketed in the category of existing pensioner on 31/3/16 as he acquired the status of pensioner only on 1 from 1/4/2016. In such view of the matter, the benefits under the revised pay rule of 2017 cannot be worked out by resorting to rule 32(1)(i)(a) and (b) of the revised pay rule, but his entitlements are to be worked out in terms of provisions laid down in rule 4A of the revised pay. This is the case. Actually, my lord, we retired on 31 in the afternoon time. So therefore, on 31st, we were effectively on the working. Therefore, effectively, I retire only from 1/4.
You retire, you work till 31st and you retire from 1st.
No, yes, I retired from 1st. If I retire from 1st, then I'm entitled to benefit under rule 4B, 4A. And the authority wanted to say that I should be treated as an existing pensioner as on 31/3/16.
Oh, how can you be? Are you not entitled to the salary till 31?
Exactly. It's a covered matter. Only thing is, my learned friend may like to have the inspection.
What? You want it?
Actually, we have served the copy about 1 hour back.
The short date may be fixed, my lord, so that I can take an instruction and. Right.
Heard Mr. Ken Chaudhary, the learned senior counsel, assisted by
Ken Mahanta.
And Mr. Eskotoki appears on behalf of the respondent number
1 to 5.
1 to 5. issue notice making it returnable by 19th of May. The extra copies of the, as Mr. S. Kotoki duly represents all the respondents, extra copies of the petition be served during the course of the day. The case of the petitioner, the learned senior counsel appearing on behalf of the petitioner submits that the case of the petitioner is squarely covered by the judgment of the coordinate bench
Page 52, madam.
dated 3/11/2022 in WPC number 1607/2020. In short, the issue involved in the instant writ petition, which have been decided by the coordinate bench, is the day on which the petitioner retires would be on 31/3/2016 or 1/4/2016. The issue which have been decided by the coordinate bench is that the person cannot be treated to have retired on 31/3/2016. And it is only on 1/4/2016 he would be deemed to have retired. And accordingly would be entitled to the benefit of the
Revised pay scale,
revised Assam what revised rules?
2017.
Entitled to the
Revised pay
Assam
rules of
State Electricity Board and Successor Company Revised Pay Rules 2017. Mr. S. Kotoki, the learned standing counsel for the respondent number 1 corporation, shall apprise this court as to whether the judgment so referred to by the learned senior counsel for the petitioner it squarely covers the issue. Liberty is given to the petitioner to mention the matter properly.
But the other matter can also be tagged matter.
Same.
Same
Retired
subject.
judge.
Same subject.
There also you are there.
Same, yes.
Retired judge also.
No, not retired judge. No, that is not retired judge.
What is that next item?
WBC 2483 of 23, madam.
Okay.
WBC 2483 of 23.
The next matter, no?
Yes. No, not next matter. It was in some other court. I'm praying for tagging both the matter together, madam.
But that matter is taken up today, no?
Okay, some other time.
13.
May I please, Lord. Basically, petitioners are assistant teacher, Lordship. Lordship, a petition pertaining to Lordship 1 period increment. Lordship, I am relying to Lordship is judgment passed by Lordship. It's a 69. Lord.
Page?
69. 69.
59.
69.
69.
Yes, Lordship, when it's a 13, Lord.
What is this matter?
Lordship, beard increment.
Beard incremental, Lordship.
Oh, that one?
Yes, Lord.
I have to dispose of.
Obliged.
The council name is same. You are for secondary
Not the secondary.
and you are for the PTC.
PTC, Lord.
Obliged.
Last order. Order transfer. Huh? 14.
Obliged.
Yes, Mr. Shah.
I'm working as assistant teacher of South Salmara and ME school.
Seeing you only, I got scared. Today the mic is not working properly on that side, and your voice is otherwise weak. Yes, tell me.
But he had prepared application for transfer to Postim Panduri ME school in a post wherein Lordship, it was lying vacant since 8/5/2018, Lord.
What do you want? Issue a writ in the nature of certiorari or a direction likeness to set aside a quashed advertisement bearing number dated to the extent the vacancy of so and so is sought to be filled up. My goodness.
Because
You have filed an application for consideration of a transfer from one school to the other. And there is an advertisement to fill up that post. What is your right?
Lordship, I don't have any right. Lordship.
Very good. Now that becomes better.
Lordship, there is an act, Lordship, under which there are certain guidelines, Lordship.
Yes.
And I fall within that guidelines, Lordship, and as per Lordship, section 10 of Assam Elementary Education, secondary.
Understood. Have you filed your application?
Yes, Lordship.
Online mode.
Both offline and online, Lordship.
Fantastic. Now what is that?
Lordship, it's pending, Lordship. That
When did you file it?
that Lordship, I filed on 2/10/2022, Lordship.
210. Where is the page?
Lordship, it's at page 48, Lordship.
48. Okay. So this you have done it.
Yes, Lordship, it's there.
Last action taken 6/2/2023 or submitted on 2/10/2022. Then what happened?
It's pending since 6/2/2023. Last action was taken on 6/2/2020.
What happened?
Lordship, the next page 49, Lordship.
Huh?
At next page 49.
Yes. Recommended.
Yes, Lordship, that was there.
He applied for treatment of teachers or their dependents to look after elderly parents and spouse in different locations. He produced singles, or hence it is forwarded to the SLC for consideration as per PTRT norms. Then,
Lordship, it's still pending since this advertisement.
so you want the transfer from where to where?
From South Salmara ME School to Pasim Panduri ME School, Lordship.
And why have you involved the chief minister?
Lordship, that was
If he doesn't give, then malafide against him. Then what? Why have you involved? There's a rule, regulation, categorically mentioned. Why are you involving the chief minister?
was done wrongly, Lordship.
How can somebody help you with all these things?
Subsequently, the office of the chief minister forwarded it to the complaint.
There the problems. He forwards it, and tomorrow you get your appointment. Somebody again comes up. You see, the chief minister has forwarded, and therefore this is extra. Now, your simple case is that you have submitted an application on 2/10/2022. It is not decided till now. And in the meantime, there are vacant posts out here which will be filled up. And as such, and urgently, the matter needs to be resolved.
Lordship, recently one.
But there is no stay in this court, in these matters.
Lordship, recently what had happened, Lordship, there was a tweet from the Honorable Chief Minister that 4,380 posts of this assistant teachers will be filled up. But then that
Will be
was
filled up.
on 11th, that is tomorrow, Lordship. But then that was postponed till 26th, Lordship. So I was apprehending.
2/26.
26th this month. Since Amit Shah could not answer.
So we have to issue notice and making it instructions by 22nd of May and find out why it has, what has happened to your application. But that is, but this court is not going to, because you don't have any right on that. Heard Mr. MP Sharma on the Learned Council appearing on behalf of the petitioner. Mr. PN Sharma appears on behalf of the respondent number 1, 2,
3, 4,
5.
1 to 5.
See, the problem arises with these headmasters being made parties.
Because in the offline application, they signed it.
Your question is only that your application you have submitted by online mode. They have not considered. Now those posts are going to be filled up. That is your, why have you involved these headmasters? Now, how can I give it on 22nd? Tell me, it can't be, process can't happen. And in the meantime, those posts are filled up. It is your problem. Does the headmaster have a say as per the regulation of 2020?
No.
Then why are you unnecessarily dragging these people? Then what does the treasury officer 8 and 9 has to do? You are not getting your salary.
No, not now, Lordship. If he is
If you are being directed there, and then you join there, and then the last drawn certificate is given by the earlier college, that comes there, and then the treasury officer does not pay you the salary, then his action comes. Tell me, your issue is small, you are making it bigger and involving the finance department. The last resort should be the finance department. Mr. P.N. Sharma is very considerate. He may not sometimes oppose unnecessarily, but you never know with the finance department. Then remove 6, 7, 8, 9 unnecessary. Heard Mr. P. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears for the respondent number 1 to 5. First, the learned counsel for the petitioner submits that for the purpose of the present writ petition and the issue involved herein, the presence of the respondent number 6, 7, 8, and 9 would not be necessary. And as such, their names may be struck off. Taking into account the same, and also upon finding that for the purpose of the issue involved in the instant petition, the presence of the respondent number 6, 7, 8, and 9 are not necessary. The names of the said respondents are struck off. The registry shall make necessary correction of the records on the basis of that, of the instant order. The issue involved in the instant petition. Oh, issue notice, making it returnable on 22nd May day. Extra copies be given by today. Okay. The issue involved in the instant petition is that the petitioner submitted an application for transfer on 2/10/2022 under the Assam Elementary and Secondary Education Transfer and Posting of Teachers Regulation 2020. Naam to Sailu Goti. It further appears from the online from the website that the petitioner's application was recommended to be placed before the SLC on 6/2/2023. In the meantime, on 11th of February 2023, the government had decided to fill up 1,433 post vacancies for assistant teachers and science teachers of upper primary schools. The learned counsel, the case of the petitioner is that a delay in the consideration of the petitioner's application for transfer would render his application infructuous if those vacant posts are filled up in pursuant to the advertisement dated 11/2/2023. Taking into account the same, this court therefore directs the learned counsel for the respondent number 1 to 5 to obtain instruction as regards the status of the petitioner's application seeking transfer. So liberty is given to the petitioner to mention the matter for upgrading.
Anna 15.
Yes, madam. Did you take the instruction?
Yes, Your Lordship, I have taken instruction, Your Lordship. Your Lordship, they have no objection.
At the request of the learned counsel for, your item was item number
72.
72. The request of the learned counsel appearing on behalf of the respondents that the instructions could not be obtained. Let the matter be listed again on 29th of May.
Deeply obliged.
Yes, Mr. Chaudhary.
My lord, the point is denial of, my lord, enhanced DA to retired judicial officers, though it is being paid to retired government servants and sitting judicial officers. With effect from
Enhanced?
1/1, enhanced DA, my lord. TNS 11. My lord, as a retired employee, supposing I am a pensioner, my lord, I am entitled to 50% of the basic pay and all other benefits. Similarly, somebody is getting family pension, then 25% of the basic pay and all other elements. It can't be, government cannot make a choice that no, will not give enhanced DA to retired judicial officers, though will give to government servants and sitting judicial officers. That's the case. At this stage, Lordship, I like to issue a notice. Madam. Lordship knows the rationale behind giving DA is connected with the cost of living.
Yes. So you are not being given the areas, or
Yes.
they are not calculating
No,
the
they are
areas?
not even extending the benefit with effect from 1/1/16. We are getting DA, but we are not getting the enhanced DA. From time to time, my lord, DA is being enhanced by different office memorandum.
Now,
all annexed.
this particular notification which was issued, normally automatically with the ROP, I don't think the Assam Judicial Service people get it. I think it has to be further extended by the government. Now, while extending, which is the notification to that effect?
Now, my lord, that I think the government will be in a better position to place those notifications.
Mhm.
But the fact of the matter is we are being denied those benefits. Otherwise, my lord, the enhancement notifications we have annexed from page 24 to onwards. For example, if your lordship kindly comes to page 24, it is 29th of March 2017. The undersigned is directed to refer to so-and-so and to say that Governor of Assam is pleased to decide that dearness allowance, dearness relief to the state government employee and pensioners who are entitled to a pension as per so-and-so shall be as per the rate shown below. So from time to time, my lord, they are issuing. So with effect
So
from
these aspects have been given to the state government,
yes,
but
state
not
government as well as to sitting judicial officer, but not to retired judicial officer. And the state government pensioners are also getting money. And in fact, the notification itself says it will be admissible to government employees and pensioners. Now, if a lordship
But
kindly comes to
this notification is only in respect of serving government employees and state government employees.
now, please come to page 42, my lord. And see, my lord, subject payment of interim relief to serving officers of the Assam Judicial Service. If your lordship would kindly come to the last para. Governor of Assam is further pleased to decide that whenever rate of DA of state government employees enhanced, he as an interim relief to serving judicial officers will automatically enhance as per the same principle. For example, if DA for the state government employee goes up by 2% and becomes so and so, then in respect of serving judicial officers, they will become so and so. The same benefit has not been extended to the retired judicial officer. Whereas, my lord, our counterpart in the state government who are pensioners, my lord, they are getting the
Now, this 2019 notification
yes
is in respect to a period prior to the Assam Judicial Service being given the 7-pay commission.
my lord. No.
Because of the fact, you see the DA, there is a difference DA. For the state government employees, it will be 19%.
My lord, this is in terms of that, my lord, judicial commissions thing, my lord. If your lordship will kindly come to this first subpara.
Now, there is the matter pending before the Supreme Court in this regard.
Yes, yes. No, Supreme, but the matter which is pending before the Supreme Court, my lord, that is regarding everything, infrastructure, That, my lord,
No, including that.
All
which-
India Judges Association.
Yes,
fees.
including the payment of certain benefits, pay and all these benefits which are there. It is already there because there was a direction which has now been extended where the government is not making those payments and it has been from time to time extended, that they're giving them direction to comply. Wouldn't this have any relation with that connection? Because then
My lord, ideally, what your lordship is saying is correct. Supposing, my lord, if the petition lies there,
now, if there is a petition pending there in respect to the same issue, would it be proper for this court? There is no problem in exercising 226. It will be useless formality.
on point of view of propriety law, then we can have that information.
I think
Lordship
better
will, like, keep it
because
pending for consideration.
because as I could see, and there is a matter is being taken up by the court number 2 out there.
Okay,
This is Sanjay Kaul and there is other judges who is taking up that matter, and from time to time the timing is being extended for the purpose of payment because the government has not paid that.
In fact, from 89, that matter is pending. Continuing mandamus is being
Yes,
issued on
yes.
all aspects, my lord.
Now, recently there has been a direction to give those benefits a day. That is why you see the difference in the DA. Here the DA is 82.5%,
Yes.
whereas for the state government employees it's 19%.
Hmm.
That is the difference because there, as of 19,
Hmm.
it has already come from 1/1/2016. The DA has been given, and this is a notification at a time when that has not yet been extended.
Hmm.
And after most probably the judgment, there might be something. You have a look at the
I'll
judgment.
have that, my
More particularly that.
No, we had a discussion on that aspect also, my lord.
Yes.
That we thought that was basically with something to do with the infrastructure of the judiciary.
No. As regards the salary also. Everything, because that they say that the same benefit has to go to the judicial officers also. And therefore, there was a direction to make payment. But the payments have not been made for which the court is being extending 1 month, 2 months, something to that effect. I'll post it again on 15th. You take your
Meanwhile, I'll
instruction.
have the instruction. Well,
Because you see,
I think my learned friend wants to say something.
Yeah.
Actually, each year, as part is Commission report, when the central government will expand the DA to the employee, and the same that should be given to the state government employee also, and the including retired judicial officer.
Yeah.
Now the case is pending before the Supreme Court because the new pay scale, a new pay pension division has not been given to us, and it is fixed on Monday. It was fixed yesterday, and again it was fixed on Monday for the hearing. That is the when the revised pay commission is given. If the revised pension is given to us, we are entitled to receive the enhanced DA of the state government given to the other employees, sitting judicial officer, and also other except the retired judicial officer. And when the sitting officer is also they are getting now they are getting the new pay scale, but they are getting the enhanced DA still in 2016 by law. Except the retired judicial officer. So those cases which is pending in the Supreme Court. Now, it is regarding the payment of the revised pension to the petitioner. It is fixed on Monday for the hearing matter. But this DA, which we are claiming, it is the enhanced DA from time to time because in a year, 2 times DA has been enhanced in the month of July and January, 2%, 3%. Those DA we are not given since 2016. There is a mistake. How it happened, my lord? In 2019, we are given 30% interim benefit, my lord. Interim benefit of me, what pension we will receive, enhanced pension, out of that 30% was given, my lord. And that should be adjusted from the final area when the new pay scale will be given effect to my lord. So that is separate component. We are given in the citizen. That is a separate component, don't DA will be. So when this interim was given, government has committed mistake. That as the interim given, they are not entitled to receive the aid. That is why our association has been approaching the government for 2 to 3 times. They are making correspondence with the judicial department, and once they have asked for the total emolument, though it is not duty on the part of the petitioner to do it, but we have brought it not so much amount. It is a 1.5 lakh something matter from the PPC pension processing unit of the state government. The judicial department, by making correspondence with the PPC, the amount has been brought by the after the submission of that amount by the judicial department, judicial department responded for their.
No, Mr. Sharma, I understand everything. There is no problem for this court to issue a notice. There's no problem. But would you get the better relief in the Supreme Court? That is what my only query. If you get the relief out there, it is one and final for everything. That is the only way. For me, for issuing a notice and this matter will be pending for some time. But if you can get the same thing there, why not do that where you are already a same aspect is being considered?
What my learned friend wants to say, my lord, the matter which is pending before the Supreme Court, that is regarding pay scale.
Pay scale, ma'am. Pay scale, the enhanced pension, my lord. What amount of pension? Because earlier it was the 50%. Whether it will be more than 50% or less than, because in earlier first judicial pay commission report, we are entitled to 50%. Now the interim report, it is here, I have given you.
Yes, sir.
In the interim report, it was stated that the enhanced pension should not be less than 50% of the revised scale. So if the revised scale is 2 lakh, then it will come to 1 lakh. So when it is given effect to from the 2016, after deducting the 30% of the income which has been paid to us, we are entitled to all the NNC also. NNC since 2016, it will be fixed simultaneously.
Because if I understand, Mr. Sharma, the all India judges case is not only limited to what you call pay, pension, or all these things. There are many other aspects of the matter which are being taken for the purpose of the benefit of the All India Judges Association. So wouldn't an interlocutory application before the Supreme Court would serve you a better purpose? That is what my consideration is. If you get a benefit out there, it's good. If not, this court, for this court to issue a notice out there, and at the end of the term, you may get some, you get it, that will take some time. It is not the matter that it will be immediately done. But there the Supreme Court is ongoing, a litigation is being taken up every day on day-to-day basis. Here is a case why you should not get it from 1/1/2016, the enhanced DA, which is being given to all other officials, not to you. So that is also a case which can be very well agitated. Just think about it. For this court to issue a notice, there is no problem out there.
The government could explain why they have not paid it.
The government can also explain there, as well as the High Court can also explain out there before the Supreme Court. And it would be much better for you to do that for them. But anyways, if you want, I can issue a notice, but that is not...
in the Supreme Court matter has been pending for last 2 to 3 years.
Where?
It is the report was submitted by the Pay Commission in the year 2019.
In this matter?
Our revised pension matter. It was the report was submitted in 2019.
Before the Supreme Court?
Before the Supreme Court, because Supreme Court has
understood, but you see the manner, the jealous in which the court is taking up on day-to-day basis that matter.
Every Monday it's
Every Monday. It is.
Monday it is fixed, my lord. No, one thing, my lord, they notice to show what is the government's, if already revised to and government is taking my lord. So the government should know that why they have withheld our DST in 2016. Your lordship kind of see the record. Our association has filed 2 to 3 representations before the
Mr. Sharma, there is no quarrel with that. But if you want, I can issue a notice. There is no problem of that. Heard Mr. Kane Shorey, the learned senior counsel, assisted by Mr. You are there in this matter, Mr. Sharma?
Yes.
Or you are a petitioner, one of the petitioners?
He's a counsel.
I have not signed a petitioner as I am counsel, so I have not signed.
Are you a beneficiary of this?
I have not read this petitioner, but it will.
Now, are you a beneficiary of this litigation?
Yes, I am beneficiary.
So better I put somebody else.
Yes, somebody else.
Fine. Yeah. Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. J. Patwari, the learned counsel, appearing on behalf of the petitioners. Oh, what about this deficit court fee?
That will do, my lord, independent. By tomorrow itself will do. More than one.
Mr. R. Borpujari appears on behalf of the respondent number 2, 3. Mr. Who appears for the Judicial Department, the Chief Secretary?
Lordship, I'm
Mr. H. Sharma appears for respondent number 1, 4, and Ms. D. Deka appears for respondent number 5. Issue notice making it returnable on when? This will require an affidavit. We'll have it on 21st of June. Issue notice making it returnable on 21st of June 2023.
Make it earlier, my lord.
Not possible. Steps be taken by 12th of May 2023. The respondent, the issue involved herein is that as the respondents are duly represented, extra copies of the writ petition being served on 12th of May 2023. The issue involved in the instant proceeding is that the petitioners who are retired officers of the Assam Judicial Service have not been granted the dearness allowance with effect from 1/1/2016, whereas in respect to the existing officers of the Assam Judicial Service, they have been granted the DA.
Enhanced DA.
The enhanced DA. The respondents shall file their affidavits by 12th of June 2023. The petitioner, if so advised, would be at liberty to file the affidavit by affidavit in reply by 19th of June. You file your affidavit.
Number 69, supplementary list.
Lordship, only last day, the direction was passed to file a proper list of this.
You have filed?
Yes, ma'am.
Yes. Now tell me.
My lord, here I have been working as a grade 4 employee at Teliapathar Navojyoti Girls MEM and has been discharging my duties since 1988. Method. Thereafter, my school was amalgamated with Sevatia Navojyoti Girls High School. My lord, that was on 20th of January 2018. Method. In the list of amalgamation, my lord, my name was not included as a grade 4 method. Thereafter, I approached the Honorable High Court, my lord, and the Honorable High Court passed the direction for inclusion of my name, my lord, and for payment of the salary that was due to me.
Now, what are you asking for? Area salary?
Yes, ma'am.
Area salary from when?
Area salary from my lord March 2018 to February 2022.
Huh?
March 2018, my lord, till February 2022.
March 2018 to February.
Yes, ma'am.
So there is already a direction submitted by here for release. Okay, now when did you become a part of the provincialized school?
My lord, that was on
Page
2013, my
32.
lord.
Huh?
Page 32, your lord.
32.
32.
Yeah. With reference, I would like to inform the government has approved the inclusion of the grade 4 employees dated in the amalgamation of Iman, issued dated so and so in connection with Iman, so and so Iman, creation of Iman. Now, what is the date on which he has been brought in? On that date, prospectively 4/11/2022.
Not yet, not yet. On
Now he is asking for the period earlier.
Not with the earlier.
What is his right to get if he is not provincialized? Will issue notice? You find out,
Lordship,
madam.
Lordship.
Heard, Mr. Your name?
My lord, P.H. Kumar.
P.H. Kumar, the learned counsel appearing on behalf of the petitioner. Mr. Ms. D. Musayari appears on behalf of the respondent number 1, 2, 3, 4, 5, and Mr. S.R. Bolu appears for respondent number 6. Issue notice making it returnable by 12th of June 2023. Steps be taken, as regards as the respondent numbers 1 to 6 are duly represented by their respective councils, extra copies of the writ petition be served upon them by 12th of May 2023. The issue involved herein is that the petitioner has approached this court on the being aggrieved by the inaction on the part of the Director of Secondary Education to release the area salary of the petitioner from March 2018 to February 2022. It appears from a perusal of the writ petition that on 4/11/2022, an order was passed by the Director of Higher Secondary Education, whereby the government, wherein it was indicated that the government had approved the inclusion of the petitioner in the amalgamation order of Tetelia Pothar Nobojyoti Girls MEM Tetelia Pothar with Sephetia Nobojyoti Girls High School under Nagaon Division. It further reveals that the said order was passed in connection with the order dated 25/1/2022 passed in WPC number 6435/2021. The respondent authorities in the secondary department is directed to apprise this court as to whether the petitioner would be entitled to the salary for the period from February 2018 to February or March?
March 2018.
March
2018.
March 2018 to February 2022, as in terms with the proposal so submitted by the head of the institution, which was countersigned by whom? Huh? No, head of the institution, which was forwarded by the inspector of schools.
Lordship, in the earlier, this honorable court's order, your lordship, in paragraph 7, your lordship, because there it was given that all the service benefits should be given from the date of amalgamation, your lordship. Service benefits are to be paid to the petitioner from the date of amalgamation of so-and-so Madras.
I've asked him whether he's entitled to. You let me know. If he's entitled to, I'll give the direction.
Okay.
70.
Please, Your Lordship.
Yes.
Petitioner is presently serving as the constable in CISF unit OPS non-Marti, Your Lordship. And he is agreed with the impugned transfer order. Your Lordship will find at page 19. By which is page 19.
19.
19 and 11, Your Lordship will find at page 21 at serial number 200.
Page 19.
19 starts.
Ah.
And 11 operative at page 21.
Page 21.
Yes, he is placed at serial number 200.
Serial number?
200.
Okay, Middle Chandra Malakar.
Yes, my lord.
You have been transferred from where?
From OPS non-Marti to ONGC Nadira.
What is your problem?
The problem, Lordship, basically on the medical grounds, he has approached before this honorable court, Your Lordship.
Oh.
Lordship will find the medical documents of his wife. First, his wife, Lordship, at page 30, annexure D. Coli. Lordship.
Yes.
On the second
That
of
is your wife's.
wife's, yes. On
Okay.
2nd of December, she has given birth to a baby girl, your lordship.
Ah.
And post-surgery medication and regular health checkup that is going on in the
Yeah.
Pratiksha.
What are these medicines? Augmentin 625 is an antibiotic. Zerodol is a pain.
Pratiksha Hospital.
DSR is a.
Under the concerned doctor, your lordship. And apart from that vaccination, at page 34 of the baby, I have just annexed. Page 34, that regular vaccination is also going on. And this is so far the
The council, are you saying that Nazira is so far backward that vaccination doesn't happen? Yes, where's the health department?
and one more
Strange.
lordship, petitioner's medical ground also is also there.
Yeah.
Medically, he's categorized the safety, lordship.
Where?
It starts from page 49.
Page?
Or page 40. Lordship, it starts from.
Yes, where?
Your lordship will find the certificate issued by the doctor.
This transfer is, which department is this?
This is CISF.
Huh?
CISF. Lordship,
Central
just for a
Industrial
moment,
Security Post.
Central Industrial Security Force.
just for a moment, page 57, lordship. Page 57, lordship. This is medical board processing.
Yes.
And here at column 7, your lordship, 7.
P3.
P3, SAFE 3, lordship, is medically categorized.
What is
in the year
P3?
2022. And he's undergoing that problem since 2019, your lordship.
What is P3?
P3 it is SAFE 3, medically categorized SAFE.
No, what is P3? I hope, Mr. Counsel, you don't expect this court to know what is P3.
It should be your lordship.
You also not aware. Then, and you say about the P3 disease for which he should not be transferred and you don't know what is P3.
Say, SAFE 3, lordship, categorized as SAFE 3, lordship.
Huh?
It is categorized as a medically safe.
Medically?
SAFE 3.
So what is the step 3?
SAFE 3 disease, lordship, there are some exemptions are there.
So if a person is P3, he should not be transferred. There must be some rules.
No, he may be transferred, lordship.
Then?
But the problem is that, lordship, at this stage, his treatment is also going on. Shifting from here to Nadira and that to with the problems of his wife and that minor.
What is the problem with his wife? There's no problem.
Lordship, in
The wife has given birth to
his
a
wife.
child. The child is now healthy and
Lordship.
he's having his immunization,
Yes,
no
my lord.
problem.
So,
And I think the ONGC Nazira duly has all the facilities. They have a good hospital out there. One can very well go. And what about the
that
P3
is why,
business? I
lordship,
don't
he
understand.
filed a detailed representation, and by that he is bringing before the competent authority for 1 year deferment. That is.
Why?
For 1 year deferment.
You are going to
grounds.
improve from P3 to P2.
On this ground, on the medical grounds of his wife.
Now, what is
and,
the medical ground?
uh,
Tell me, what is the medical ground of his wife?
under the concerned doctor, actually,
That the vaccination has to be taken.
vaccination is also there, but the health checkup of his
Huh?
that medical health post surgery health checkup is also going. At least for 1 year, that department he sought for before the respondent doctor.
No, Mr. Counsel, court is not satisfied with this.
And lordship,
I can at best say that this representation which have been submitted, you will proceed to the destination and the representation so submitted shall be duly considered by the authority.
lordship,
That is the only thing you can get from this court.
in another matter also I present for this honorable court. The direction was
Mr.
given.
Counsel, other
Direction-
courts are very lenient. They are
ma'am.
good, not nice like
Direction
me.
was given to dispose of that representation, lordship, but till then status quo that direction.
What?
Status quo.
State.
Till then, lordship, till disposal of the.
My direction would be you join them. Then thereafter the authorities will consider the representation. That is it.
It is joint.
No, then also they consider. Isn't this a central government, this force comes under the central government? Seeing Mr. UK Goswami appearing out here?
Yes, my lord.
Obviously. Then go to that, out there in Delhi. What is that? In Delhi, there is a big hospital out there for defense forces near Dholakua. Take him there. Get your posting out there in Dholakua.
Since the
You want
petitioner
it?
represents.
There is also the CISF. Huh? Heard, Mr.
D. Bora, Your
D. Bora, the learned counsel appearing on behalf of the petitioner. And Mr. UK Goswami appears on behalf of the respondent number 126. The petitioner here has approached this court by filing the instant writ petition challenging the order dated 3/5/2023. 2023, whereby the petitioner has been transferred from
OPS non-mati.
OPS Nunmati to ONGC Nazira. It further appears from the order itself that it is an inter-unit transfer. Be that as it may, it is the case of the petitioner that a child was born on 2/12/2022 to the petitioner and his wife. And there's a requirement of certain, that the process of immunization of the child is going on at Guwahati. Further to that, it is also the case of the petitioner that the petitioner has been diagnosed at the P3 step.
There is lower medical category.
It is also apparent from a perusal of the writ petition that on 2/5/2023, the representation has also been submitted to the Deputy Inspector General CISF Headquarter NEZ, Guwahati. However, as the said representation has not been taken into consideration, the petitioner is before this court under Article 226 of the Constitution. I've heard the learned counsel for the parties and also have perused the materials on record. The scope of jurisdiction under Article 226 of the Constitution in respect to transfer matters is limited and circumscribed as held by the Supreme Court in the case of Public Services Tribunal, Bar Association versus State of UP and others, reported in 2003, 4 SCC 104. Wherein the Supreme Court had categorically observed that it is only in rare cases where the transfer has been made in the vindictive manner, such transfer can be interfered with. This was so observed by the Supreme Court, taking into account that the transfer is the incident of service. Now, coming to the submissions, case of the petitioner. That the newborn baby's immunization process, immunization and vaccination is presently going on at Guwahati cannot be a reason in the opinion of this court, taking into account that such services are very well available at Nazira also. As regards the ailment of the petitioner as contended in the petition to be a P3 step. What is that, Mr. Goswami?
Lower medical category. This category is a lower medical.
P3?
What
What is the meaning? P3?
Safe free.
Safe 3.
Step 3. Step 3. P3 step 3. It has been submitted by Mr. UK Goswami, the learned counsel, for the respondents that it comes within the ambit of a lower medical category. Taking into account the same, this court does not find any reasons to interfere with the said order, impugn order dated what is the date?
Lordship, 3/5/2023.
What is that order date?
3/5. Pardon me, Your Honor.
This is 19 months.
On 3/5/2023. It is, however, this court also deems it fit that the petitioner would be at liberty, after complying with the order of transfer dated 3/5/2023, to submit a representation to the authority concerned, we shall duly consider the same in accordance with law.
The movement order has not been issued, Your Lordship.
You want the court that I should ask the authority to issue a movement order?
No. Obliged.
At number 16 to 21.
Oh, what happened? Are you getting any money?
As
What
of
is the
now-
finance and
as
Mr.
of now,
Thor
we have
doing?
not seen any money till.
Huh?
As of now, we have not seen any money.
Yes. Why haven't you paid any amount to
My
these
lord, I have
people?
received a small instruction.
With reference, I am to inform that the proposal submitted by so-and-so, the proposal was forwarded to the government by the directed so-and-so amounting to rupees 2 lakh for so-and-so for payment of the area and remand to the petitioner with the proposal of the the finance has raised queries against the statement. The queries were replied by so-and-so dated. Yes, finance. What is your instruction?
That proposal has not come from the government, and I have already taken up the matter with the budget department. I have just not spoken with the deputy secretary. He said that, my lord, that is system generated and that got lapsed. Then
Which got? Oh, the 2 crores.
Yes. Then again, my lord, in the monsoon session, they will have to move a proposal.
Huh?
In the monsoon session, they will have to again move a proposal for supplementary demand. And once that it is moved, my lord, because now.
So the fact that they are, Mr. Sharma's clients say that they have not got a single penny is true. The lapses on the part of the Mr. Dhor's client is apparent because they have not sent it, for which it got exhausted.
My lord, we have sent it, my lord.
You have sent it now, not this way. Why haven't you given it? They have already, they say that they have sanctioned the amount of this 2 crores.
My lord, we have sent
You
it.
have not given it to them. That is the reason why they all
My
have
lord,
lapsed.
we have sent it before March
To whom?
to the from government to finance department. That is their date is there, my lord.
No, they say the sanction has already been given to 2 crores. Now, because of this has lapsed, now we have to again submit at the monsoon season. Now we have to expect when the monsoon comes. Or is it on the fixed date?
It will be in the month of July and August, because these amounts are earmarked, my lord, on financial year basis. So therefore, in my instruction, it has been specifically stated that for the financial year 2022 and 23.
My lord will.
So that proposal didn't come now for this financial year, current financial year.
No, but Mr. Korpujari,
Yes.
You have seen the state of affairs of this corporation. If the government does not provide the benefit, certain aids with the rented houses, they can never do.
My lord, we have.
The amount,
Yeah.
as if I remember on the last occasion, what demand has been made for the doing is not 200 lakhs, but it is 1719, if I remember correctly.
Yes.
1719. So if it is a 1719, where will they get with the rent? That to some Tinsali rent.
Now, here the whole difficulty lies because nowadays it is absolutely system generated. There is no.
I don't know all these things, but the government has to do something as regards these people. Yes, there is a corporation.
Now.
But you see, the government appointing, government, it is not that there anything to that effect. The government appoints somebody as the chairman, the managing director, meaning that the government has a control over it. You do everything, the government has to, but at the time of paying salary, the government says that we have no business out there. They have to get it from their own rents. They do some work out here and there from the plain tribe thing, but they give some meager amount to that. How will they survive with the huge amount? Now, on the last occasion, the managing director came out here that on in a particular year in 2028, 28 now.
28.
When you are going to reduce it to 48?
30.
30. So how do you do unless you have a proposal to liquidate this amount? Ask them to sell up their houses.
No, my department.
No, not your department. The government has to take a decision on this. Something has to be done. Your department, his department, I am not concerned. But these people have worked, they have entitled to their salary or the area pension or whatever it may be. This was a contract. Now, unless this court has put it out there for the selling of those units, something has to be done.
Absolutely. Absolutely. We all are alive today. Not that we are not alive. Very much.
Alive or not alive, it doesn't help it. That something concrete has to happen.
This is apparent, my lord.
Apparent for what? In one matter, I found out there's another, that is the warehousing corporation. It's also in a way sad state of affairs. They got some money of 5 crores and then they paid some amount. Then luckily, they have some land which has been given to the oil. For that, they are getting some rent. Otherwise, there is nothing out there. But for them with rented tin houses, what are they going to do?
And in fact, I have been just now verbally told by
The government has to take up,
Yes.
has to take a conscious decision that something needs to be done, either to close the corporation or run it, then do something or revive or revamp. Something has to be done. On one hand, you are saying that we are doing a lot for the purpose of progressing the tribals in the country, and then nothing. If the tribal corporation and that affairs department is in such shambles, what will happen? So what to do? Something has to be done.
That proposal will have to come. Once that proposal is there, my lord, immediately.
Understood, they will give us. Is it the fact that you are only going to give it? You don't have a contingency plan?
Contingency fund is there, my lord.
Then why the contingency fund is not being used? The government has to be conscious about this. That I would have understood that it is some corporation, the government has no control, nothing to their effect, it's a different aspect. But the government appoints those people. The managing director is an appointee of the government.
Only the managing director, madam. Managing director.
Who heads the corporation? Isn't it?
But he doesn't again take the salary from the corporation, madam. He doesn't draw any salary from the corporation.
Fantastic, but for the petrol he takes from the corporation. The accommodation, rent accommodation is from the corporation. You want to see that? See it. Because I remember all these things. You need to look into it. What was the proposal submitted on that particular date? You have a look at this. See, honorarium to vice chairman and remuneration of two numbers of peon of chairman and vice chairman, 8.30 crores. Petrol, oil, lubricants to the chairman and vice chairman, 4.92 crores.
My lord, again, chairman and vice chairman of the board, the corporation, they are not the part of the government, my lord.
Then what is the managing director doing there? Why you are having a managing director if there is a chairman out there? What business does the managing director have?
My lord, managing director looks over the day-to-day issues of the corporation, my lord.
So he is squarely responsible. Why is the managing director being appointed by the government? To look into it, that it is within they are acting in terms with the mandate of the government. So that the chairman and the vice chairman or the members of the board did not put the corporation into astray. That's the reason why you are having a managing director. And then if he can look after everything and then you say that the government has no business out there, how can you say that?
Chairman is also a member of legislative.
Huh?
The chairman is also a member of legislative. The chairman.
Legislative Assembly.
MLA, my lord. He's an MLA.
By dint of being an MLA or by the otherwise? The government appointed. Who appointed the chairman?
That is government appointment.
Yeah. Sir, not only the managing director, the chairman also. And he takes his honorarium from the government. This petrol, traveling expenses. All these things are well. For this person who is from the Legislative Assembly, for them there is no problem. But for what will happen to these poor people? They have retired, expired, existing, no salary. I have asked you about the proposal of 3/2/2023. What happened to that? You are referring to a 200 crores, 200 lakhs. I'm not on that. This is the proposal which was submitted of 226 crores. What happened to that? That was my specific question in the order.
226. An amount.
You don't have the instruction in that order.
My lord, this is the last proposal.
No. You see my last order. There's been particularly Mr. Ardhor, the learned counsel appearing on behalf of the Tribal Affairs Department, submits that he will be required to take instruction as to whether the said amount which have been sanctioned has been disbursed to the corporation. That is one. And as to what steps have been taken pursuant to the proposal submitted by the managing director of the corporation to the director of Tribal Affairs on 3/2/2023. What happened to that? No instructions to that effect. Heard Mr. A. Nath, Mr. S.K. Jain for the petitioners. Mr. Ardhor appears for the Tribal Affairs Department of the Government of Assam. Mr. Arbo Pujari appears for the Finance Department, as well as Mr. A. Sharma appears on behalf of the corporation. What is that corporation name?
Assam Plain Tribe
Assam Plain Tribe
Development Corporation.
Development Corporation. The queries which were made by this court in its order dated 27/4/2023 have not been answered by the counsels appearing for the Finance Department as well as for the Tribal Affairs Department. On the other hand, Mr. R. Bopuzari, the learned counsel appearing for the finance department, submitted that the finance department has not received any FOC proposal during FY 2022-23 for payment of outstanding area salaries and retirement benefits of the employees of Assam Plain Tribes Development Corporation against the budget provision of rupees 2 crores earmarked in the supplementary demand budget December 2022. It has been further mentioned that the department may move fresh CF proposal after supplementary budget proposal for the budget provisions during the current financial year 2023-24 for withdrawal of the outstanding area salaries and retirement benefits of the employees of APDC Limited. On the other hand, Mr. T. Ardhor further submits upon instructions from the Director of the Tribal Affairs Plains Department which is only in relation to the proposal submitted on 27/12/2022. However, as regards the specific query which was being made pertaining to the proposal submitted on 3/2/2023 by the Managing Director of the corporation to the Director of Tribal Affairs, there is no mention in the instructions. As the instructions which were sought for in the order dated 27/4/2023 is not forthcoming from the respondents, more particularly from the Finance Department as well as the Tribal Affairs Department. This court fixes the matter again on 29th of May 2023. It is observed that if the instructions so sought for is not obtained, this court would have no other option but to call the authorities of the department to be personally present on such date as may be fixed.
There's another similar matter, if that can be also tagged along with this.
My lord.
4503.
My instructions are clear, my lord. We have not received proposal. Once we receive proposal, it will be released, my lord. We will take a decision.
Okay, finance behavior from them.
It is clear, my lord, absolutely clear.
From them.
Only the instruction regarding the main proposal. 17.
We are concerned with that 70 because 17.19 crore would meet everything for them.
Yeah.
That has to be done something. And finance, you do something, work it out, what is to be done. Because they have to get or allow them to sell the houses.
Yeah.
And then they become, where are your assets? You have filed their assets. No?
I have already filed an affidavit to that regard.
Where is it?
And that is in WBC number 4503/2021, which I wanted to be tagged along with this matter.
Okay. List the matter along with WBC number
4503
4503
of 2021.
2021.
I filed an affidavit.
At the affidavit, then we will note down which are to be sold off. Now with auction nowadays, where you have those houses?
Here and there.
In Guwahati?
Guwahati, but it's not in a very good condition. Those places.
Not necessary.
And in some places,
Guwahati, any property will fetch good amount for
and
them.
in some lands, there is already some title.
No, their amount is 1.76 crores.
Title.
I am not concerned with others. I am only
Title is under
concerned with
challenge
them.
in some land.
Huh?
The title is under challenge in some land.
Okay, they can purchase.
those
Somebody
issues are
will
also
purchase. There are people who purchase it. No?
Litigation is also going on for regarding title.
Because as Lordship has rightly said, it is 1 crore 76 lakh.
For them.
For them. finance has already given a sanction of 2 crores, more than 1.7. Now it is for them to move that proposal. They can move it.
Understood, you have given, yeah, but that 2 crores is also consist of the existing salaries also.
Yes.
Why haven't you mentioned that while giving the proposal only in respect to these petitioners? No, you have said about the existing salary. Their problem, you see, you have tried to make these people fight with the existing people. Can't do that.
Will be for a public purpose, you have to give certificate of its compliance or will take penal action under a particular act.
That was
In fact,
lordship,
that I'll
all
read
the law
after it.
colleges lordship. One time that grant was given lordship, otherwise we have no.
There is no
nothing, any
situation
financial
of,
control.
one time, this was mentioned in the JV Law Colleges.
Even JB Law College also lordship, one time grant was given lordship.
Okay, let's hear the Guwahati University. What control you have over the service conditions of these colleges?
Lordship, under conditions of law college, 7 number, the college shall also undertake to follow the statute, ordinance, rules and regulations of the university and bar councils of India to be issued from time to time.
So as per you, there is a statute of the Guwahati University. So that needs to be followed by all affiliated units, affiliated colleges.
Yes, sir.
Okay, does the statute mention anything about the service conditions? And what steps do you take if it is not being done so? What steps you can take if an affiliated college does not comply with your statute? Or is it just for the sake of mentioning in the affiliation order you mention it?
The 3 years degree course permanent affiliation with effect from 2010 to 11, Lordship. And 5 years degree course temporarily affiliation with effect from 2012 to 13. And 2 years LLM course temporarily affiliation with effect from 16 to 17.
No, anyway, when they give a law degree, it has to be, can't be a law degree from Tezpur Law College. It has to be by some university. So university is yours. Do you give the law degree for them?
Yes, sir.
You give it. That means they are affiliated to you. Now, if they are affiliated, there are certain requirements to be fulfilled by the authorities, by that affiliated unit, which means they have to take note of follow the statutes. Now, does your statute have a control over their internal arrangements?
UGC regulations and Assam Service Disciplinary Appeal Rules 1964 is must be applicable.
So it is applicable
Yes,
to
sir.
them also. How are you making it applicable to them?
No, not applicable. Lordship.
Not applicable. Okay. Now it gives a totally 180 degrees somersault. Okay, then. No, if an affiliated unit, as in the instant case, does something which is not in accordance. The first and foremost, therefore, I ask as to whether the Guwahati High Court, Guwahati University has a control over its affiliated units as regards the service consideration conditions of its employees of the affiliated units. You have a service conditions for the purpose of the people who are working in the Guwahati University. There's no quarrel with that. But whether those service conditions are to be also applied to those affiliated units?
No.
No. Yes, Mr. Das.
On the first
Tell me, what is the case of means why you are alleging Malafide?
Malafide, before Malafide, one thing I'd like to point out, which my learned friend did not point out, the university statute clearly states that what your lordship has just now said. If I may read the affiliation part, because affiliation gives a statutory color to the private colleges, which they are saying it's private, it's not amenable to any jurisdiction. If I may read the statute, the Guwahati University Statute of 1998, no law colleges shall be granted permanent affiliation up to any specified period unless the Executive Council of the Guwahati University is satisfied through an inspection report that the college has been working on sound line, have good management, is properly staffed, is well-equipped library, financial stability, own land, permanent building, and has complied with the relevant University Bar Council of India rules. Page 11, Lordship. Serial 13, if I may read again. No law colleges shall be granted permanent affiliation upon any specific period unless the Executive Council is satisfied through an inspection report that the college has been working on sound lines, has good management, is properly staffed, has well-equipped library, financial stability, its own land and a permanent building, and has complied with the relevant University Bar Council of India's rules, regulations, statutes, ordinances, and all other directives issued by the university and Bar Council of India from time to time, provided that no colleges, law colleges will be granted permanent affiliation before expiry of 8 years from the first temporary up to standard 3 or LLB part 3 standard. The functioning of the permanent affiliated colleges may be reviewed by the university as and when necessary. In fact, taking a cue from that, the Tezpur Law College, in its article of association at serial 14, clearly says that on expulsion of any members of the staff, teaching staff who gets permanently employed, like the petitioner, they have to follow the Guwahati University regulation. They would not have brought it, the articles of association would not have incorporated this provision if the statute did not give them the power, number one. And number two, the Guwahati University regulation fully, I've also gotten information from my college where I worked earlier, is fully, they follow the Assam University, the disciplinary appeal rules 64, because they don't have any system of their own rules, that thereby meaning that the colleges, the different affiliated law colleges also, whenever disciplinary proceedings come up, they follow it. And in fact, the university, as soon as the university affiliation is there, the statutory character.
No, but Mr. Das, merely because the Guwahati University regulations would be applicable for regulating the conduct.
Yes.
Would it mean that the Tezpur College will be a state or other authority within the meaning of Article 12?
No, it's not state. We are not on state.
No, other authorities.
Other authorities within
would it
the
come
meaning
within
of
that because they have to follow a particular rules
yes,
and regulations?
Other authorities, 226 clearly says the writ can be issued.
No, it would be at best a statute of incorporation being brought into the fold by way of the articles of association.
Yes.
That's all.
Yes.
But whether the statute of incorporation makes them come within the ambit of Article 12?
Yes, because basically whenever service conditions of teachers because the other, university, the law colleges teachers who have approached this code, in fact, in the JB Law College's judgment, it was referred that since till the time the university or the bar councils come up with any sort of independent regulation for the law college, because law college, though it's a professional course, has always been neglected by the government. And as a result, unlike the medical or other professional course, so the statute of university regulates them. And the article of association of that university, that our college, the Tezpur Law College, has basically taken the statutory color in it, because by incorporation of that particular Guwahati University rules and regulations, the concept of the objections which the university, the college is now taking, that we don't come within the purview, it's a private body, you are not amenable. That has been sufficiently stated in the Supreme Court judgment. In fact, Lordship yesterday's judgment 2015, where an elaborate judgment was given, and in fact, it finds also reference in another judgment of the Supreme Court in Vinny's case, where
the 2015 judgment was a case where that particular university concerned was a deemed university, and in terms and thereby recognizes the deemed university by the University Grants Commission.
Yes,
but this is not the fact out here. It is not a deemed university.
It is
it's
not
just
a deemed
college.
university, because we can't be a deemed university because we are an affiliated university. The question of the statutory, the power of the statute is coming through the Assam University regulation, because ultimately the university regulation clearly stipulates that they have to, the affiliated colleges has to follow the rules and regulations. In fact, your Lordship has seen that whenever
Tomorrow, let us have an example. The Don Bosco out here follows that. Let us adopt for the purpose of regulating the suspension of the disciplinary proceedings, the Assam discipline and appeal rules.
No.
For the purpose, would it make it a state within the meaning of Article 12?
Yes, that's my learned friend has not distinguished it. It's a minority institution. Minority institution, constitutional protection under 30 is there. The state cannot come in unless there is a mismanagement.
Let us now draw the attention of Royal Global School or Sarda Birla. Would they say that let us, for the purpose of suspension, we will adopt the procedure which is being mentioned out there in Assam discipline and appeal rules? Would that make it other authorities under Article 12?
No, but the other authority is under the entire case. My case is built on the fact that the procedure, Lordship had put a very pertinent question, that what is the remedy provided? In the other statutes in the Supreme Court, St. Mary's case, a tribunal was constituted, which takes up the grievance of the persons if any service condition issues come in. Secondly, the contract of personal service, and I brought in another workman industrial dispute that doesn't come in. My case was mandamus couldn't be issued only because the fact that the law colleges is imparting public education, legal education, the technicalities of 226 not coming in, because the 226 Lordship, I have already said, it's a more extensive power than 32. And there it cannot, since 1952, the Supreme Court has said it is not unlike the English prerogative writs, which the king used to exercise, because we in India have a written constitution. So our rights are guaranteed. And here the question of fairness is that I come to the court for justice, oblivious of the fact that I never think also that I'll be put under suspension on the ground that I am called in, that you attend the meeting to explain why you went to the court. I rightly refused, because the matter, semblance, I'm a teacher of law, I know that the matter is sub judice. Why will I go and attend it? On the ground that I didn't attend, within days, I was placed under suspension. That's the reason I came before your Lordship. So the legal malafide is such an issue where the question of now, when the Supreme Court is expanding its scope of 226 and 32, 32 is an exclusive power. In fact, in the Pottaswamy's case, the 9 judges Supreme Court has brought in concept. Privacy was never a right earlier. But after the 9 benches, privacy is a right under 21. It's a fundamental right, which was refused in Kharak Singh's case. So my case is that the fact that the exercise of power is vitiated, I'm not talking about factual spite vengeance of the respondent number. I'm talking about an improper exercise of power for collateral purpose. The only purpose is that, and the allegation which they bring in that I countered it in my reply, that it's all an afterthought. The authorities became wiser when I approached this court, because they said that I have completely mismanaged, misappropriated, lots of financial anomalies were there, oblivious of the fact, and also said that I was never a secretary, oblivious of the fact that the secretary part came in only when I went to the court. In fact, they say that when we checked the records after you went to the court, we found that the secretary was not there. But then after they countered that you were the secretary, because the president and secretary was always signing from 2020. So basically, if your lordship sees the reply given affidavit in opposition, it is lies and falsehood, because they wanted to build up a case. In fact, the action is when they place me under suspension for 90 days, they don't give me charge sheet. The day when the matter came up for hearing, they took time on the ground that they will consider my representation to get a decision whether charge sheet should be given, and I come to the next stage. So this was not done, and I came it also on the ground that there is a concept of UB just IB remedium, where there is a right, there is a remedy. Notice was not given. In fact, the Supreme Court's
You
law.
have a remedy before the civil court.
Malad?
You have a remedy before the civil court.
No, but I am availing a public law remedy.
There might
Will I
be
be at the
tomorrow a
stage?
dispute may be there between two private individuals. And then if you want to initiate a public law remedy, then the Supreme Court has been clear not to exercise such jurisdiction.
But when my matter was notice was issued and I have come at the last stage of hearing, can that maintainability issue be brought in to say that I don't come under 226? That is too far-fetched.
That was a matter pertaining to the Supreme Court in AIR 1971, page 33.
Yes.
Where it has been there, where the matter was heard at length and the matter having been admitted. And as such, and the hearing has already commenced, then to say anything on merits and then refer it back that on the ground of the alternative remedy is not good. That was said to be bad.
What I propose, the fact that your lordship wanted to hear my case.
Your case. This
Yes,
is what I'm asking you.
I'm
You come with your case, then we will
Yes,
further.
no,
Because you see, we are not getting any help from the respondents.
Yes, but
So let us see if it is so unjust that this court should exercise.
Yes.
Because Mr. Nair on the last occasion yesterday said that 30 days they are going to complete the disciplinary proceedings.
Yes, madam. And in fact, it was really a ball from the blue when they at this stage. I never expected that they will bring in this 226 maintainability.
You never know when Mr. Nair is appearing on the other side.
Yes, my lord. Maintainability thing we left long back. Now we are in Puttaswamy.
Yes.
And Kaushal's case. So I never knew. So I'll start my case, lordship. But your lordship will take up my writ petition 609. What has happened? The petitioner is at present, though under suspension, was a regularly appointed principal. And in terms of an advertisement issued at Annexure H, page 20, on 6th of December 2019, she applied for, if I may read the advertisement, applications, page 20.
Then
applications are invited from intending candidates for the post of principal whole-time for Tezpur Law College. Candidates fulfilling requisite qualifications and experience as per norms of the Bar Council of India and UGC may apply within 10 days from the date of the publication. Salary will commensurate with the experience. I applied, and at page 21, the selection committee's recommendation for the post was dated 2/2/2020. We have conducted an interview for selection of a whole-time principal of Tezpur Law College today. That is at page 21.
yes, no, I've read it.
Yes. Then I get selected. And immediately on 3rd, I joined 3/2/2020 as a whole-time principal cum secretary of the governing body. And on the 3rd, that is at page 23, I give my joining.
Yes, this document why you are not referring to page 24?
Yes.
Whose document is this?
Well, this is from respondent 5, the president.
Yes,
Where-
so now you see Ruby Dutta, who is
Yes.
Ruby
Well,
Dutta?
what has happened?
Huh?
While I was the principal.
You are the principal, you are Ruby
I'm not
Dutta.
Ruby Dutta.
Okay.
I'm Ruby Dutta is another teacher.
Okay, now look here, let's read the particular document at
Yes.
page 24, NHE.
Yes.
You are a secretary, no?
Yes, I was all along because the
No,
principal.
you were a secretary.
Yes,
Okay,
secretary.
now read this document. This is
Subject,
written.
appointment of secretary governing body, Tezpur Law College. Dear sir, madam, most respectfully, the undersigned would like to convey as per resolution of the governing body that was taken in the meeting held on 19, that you are appointed as the secretary of the Law College as per Guwahati University Regulation 6 with immediate effect up to 31st March 2003 on a purely temporary basis. The duties and responsibility of the secretary will be as per our ordinance on permission and affiliation of Law Colleges 6 and MOA of the Tezpur Law College. You are requested to accept the responsibility and render valuable service for the betterment of the institute.
So he duly admits this president of the governing body that for the purpose of the post of the secretary, this person whose appointment is in terms with the GU Ordinance 2006.
What has happened? This is another case which is pending. What has happened while I was the secretary, these rules on the secretary who exercise financial power, the principal is always the secretary of the governing body along with the president. What happens? It's a elected post. And it usually is continues with the principal unless and until certain serious allegations are there, the secretary post cannot be removed. My case was that all of a sudden on 21/11/2020, without giving me notice, you appoint an assistant teacher, professor under me, as secretary on the ground that I don't. Verbally, I was informed that you are not good in management and financial management. So I'll give another teacher. Oblivious of the fact that this, the down below, your lordship will find that the governing body, other teachers of the college gave a representation, which I'll read. The above matter is still pending and not confirmed by all the GB members. The principal and the teachers representatives strongly oppose the matter and it is not accepted by the GB president. Well, what has happened? I was removed without any reason and immediately I approached the Guwahati High Court with a writ.
Show me your suspension order.
Yes. This suspension order is at page 28, Annexure I 31/2003, 23. Sorry.
You have been suspended as the principal.
Yes, my lord. I have been suspended as the principal. My entire case was that when I was removed from secretary, rules were not complied. I approached this court. The Guwahati High Court issued notice and told the authorities to immediately place the record for the consideration of the interim order. Because I made a statement or note that verbally I was removed from secretary and the secretary post always stays with the principal. And now it is next to impossible for an assistant teacher to take over. My allegation was that the president possibly wanted his person to be there. And this was only the way to bring me out. And when they could not answer it, it is at that stage that I was suspended. And then I come up with this petition bringing in legal malafide. That was my basic. Will I read the suspension?
Yes.
This is a letter from the president. Madam, as per decision of the emergent governing body is meeting on 29 January 2023, based on your act of dereliction on duty and total disregard to the governing body, which is negative to the post held by you, you are placed under suspension pending withdrawal of proceeding against yourself with immediate effect. It is also directed to hand over all the office keys to the exceeding principal in charge, appointed by the governing Dr. Dulumoni Nath, Assistant Professor. My lord, if your lordship, then your lordship will come to the earlier page, lordship, where I was informed, your lordship will come to page 25. This is very important. This is a letter, page 25 of 27/1, about 3 days prior to my suspension, from the new secretary, who writes a letter to me informing about an urgent governing body meeting. That is at page 25, annexure F, if I may read.
25.
Yes. This is the new secretary. In fact, the case was pending at that time. I made Mrs. Ruby Dutta a party. Urgent. Madam, this is to inform that Smita Barua Deka, principal, has filed a writ petition in the Guwahati High Court against the governing body. The case was taken up by the Guwahati High Court on 19/1, and a copy of the order has been handed over to the Honorable President and Secretary, governing body, Tezpur Law College, by the principal, Tezpur Law College, on 21. The Honorable High Court has fixed the next date on 28/2. In view of the same, an emergency governing meeting has been convened. The meeting is scheduled at 11 at Moot Court Hall. I cordially request you to attend the same. To this, I give a reply. I give my reply, and I inform that my reply is at page 27, 28/1/2023. Unable to attend. In this regard, it is to intimate that the governing body must be called without any prior consent with principal, Tezpur Law College, by the secretary. An explanation has been called to the secretary on 27/1/23. The secretary is not the governing body member as per the Guwahati University rule, and she violated the rule prescribed under the above Guwahati University ordinance, because this was a subject matter of my earlier writ petition. The agenda mentioned in the letter to discuss about the writ petition and steps to be taken by the governing body is not a question of discussion by the governing body members. However, the case is pending at the Guwahati High Court, and I would like to clarify that the petition is filed against only President, Mr. Hazarika, and Secretary, Ruby Dutta. There is no involvement of any GB members in this case. I would like to also inform you that the writ petition is against the arbitrary and illegal action of the President to remove me from the post of Secretary in complete violation of statutory rules and appointing a faculty to the post. The matter is under judicial scrutiny, and I won't be in a position to comment further in a meeting conveyed by the present governing. Therefore, I am submitting my unavailability for the due of this meeting. Well, day one.
Mr. Das, where is the Guwahati University statute anywhere?
Yes.
And the regulation?
Yes. Well, the 98 regulation. We are given a.
Because whatever may be, your long and short story about this case is because of the fact that you have approached this court.
Absolutely.
And as such, you have been victimized. That's your case.
That's my case. Well,
That
my
I've
first
understood.
case was never.
But the fact that it is the principal who, by dint of being the principal, becomes the secretary. Where can I find that?
Malad, yes, it is in section 10.
Because if you see at page 54 of their reply, I suppose, I think the running page 54.
Yes.
Election procedure of the executive committee, governing body, managing committee. Citation also. Yep, citation.
My lord, if your lordship will come to the requirement at page 9, lordship.
This document,
Yes, sir. Page
is this
9.
is this the Guwahati University
Yes,
statute?
this is the statute of regulation which governs. The Guwahati High Court single judge has also said this will hold the field. Well, lordship will come to page 9H.
9H.
The president and the secretary of the governing
9H.
9, lordship. the heading
9 I
is-
found out. 9A, then
10, lordship, sorry, lordship.
10H,
Requirement
10H.
of LLB to.
the president and the secretary
Yes,
of the
the
government shall
president and
be.
secretary of the governing body shall be elected by the members from amongst themselves. Where the principal is not the secretary, he or she shall be the joint secretary. My case was hinging on this, that I was, by virtue of my post, I was elected. And you are now selecting on your whims and fancies, assistant professor by the name Ruby Dutta, oblivious of the fact that no semblance of fair procedure was established. Because I was just called in my first petition, I bring a serious allegation. I was called in and said that you are an incompetent principal. So I am giving my person. It is
Okay.
at that stage I come to the court.
Okay.
That is.
Yes, madam. Oh, Mr. Nair,
I'm sorry, my lord.
tell me out here, what is the basis of suspension?
My lord, the basis of the suspension is, my lord, now it can be more clear from the charge sheet that we have issued to her, which is again based on the records.
No,
I'll
no,
just-
no, Mr. Nair, a charge sheet is submitted subsequent.
My lord, the allegation.
But the formation of the opinion for the purpose of the charge of suspension has to be, I think, preceded.
Yes, your lordship.
Where is
The
it?
governing body is meeting. Therein, my lord, these allegations were prima facie brought on record. And the governing body.
Where are the records for that?
My lord, I have everything with me, but today, my lord, I'm really sorry, my lord. I got stuck in a matter and I'm totally distorted, my lord. Today, I'm not in the correct frame, my lord. I'll place that, my lord. I'll place that. Well, what had happened was these allegations were brought before the governing body. The governing body examined it, and
Okay,
then
now how did you bring it to the governing body?
the records, my lord. I have everything with me.
No, how did you bring it before the governing body?
The governing body members, my lord, on examination of the records, her conduct, the financial irregularities that were taking place, the office made the put up the matters. The governing body considered that matter.
Now kindly come to this affidavit filed by the respondent number 5,
Lordship.
and more particularly to page number 54.
My lord will have 53 before that.
53, what is it?
Lordship.
Yes.
My lord will have 53.
Ah.
Many things are being said now. My lord will have 50.
He has not
Yes,
said, I have said more.
53, my lord. No, my senior has placed that. My lord will have 53, my lord.
Yes.
This is the way we operate, my lord. This is made by my friend's client, my lord, the petitioner. Subscribe donation, public donation as decided by.
Didn't the respondent number 5 also sign it?
He has signed it, my lord.
So it is not
But the-
only him.
But the main signature, both are responsible.
Absolutely. And then also, if you see this particular articles of association, the photographs of many people are there,
Yes,
including
Your
the clients at
My lord,
page 50.
my lord will have just that for 53.
So who has done it is not material.
No, I'm not on that.
Yes.
She knows it, my lord. I'm only on that. She knows it.
Yes.
53.
Now,
Now they said that government fund is there, this is there, that is there. My lord will see what is written here. Public donation as may be decided by the board. Collection of fund, students enrollment fees, casual government grants, etc. as decided by the government body. Because this funds was given only in once, my lord, sometime in 2013, thereafter nothing. And now I have got instructions, even the utilization certificate thereof was not given. Now my lord would come to page 54. This is the governing body.
now kindly come to 8, serial number 8. Election procedure of the executive
As per
committee.
the university statute.
Which is that?
It would be this. This came subsequently.
Because you have two things. One is as per university statute, and the second at 11 as per Guwahati University regulation.
Regulation.
So these are obviously two different
Two
things.
different
Otherwise, why would they mention it in this matter?
And Lordship would notice in 14, it pertains to expulsion of a member. So expulsion of a member, it pertains to expulsion. Expulsion
No,
has
I'm not on that.
Well,
You see, no, the reason is we can further go into another aspect of the matter that if a governing body meeting has been called
Lordship.
by an person concerned who could not have been a secretary because of the pendency of another writ petition where there is a challenge to that, although there is no stay to that effect. But if it is being called and on the basis of that a decision is taken, then what not? So that is why I wanted to see what is this.
I'll get it, my lord. But if Lordship can have it on Monday, my lord. If not, my apologies for that.
Yesterday, Lordship has said I am on leave.
I know that. I know, Mr. Das. That is why I allowed you to
Yeah, my lord,
argue
my
out
lord,
there.
my lord.
Don't worry. I'll take care of whatever it is. I've got your point out there. Your basic point, without saying anything else, is first and foremost is the writ is maintainable in view of the recent Constitution Bench judgment, which has a horizon.
Horizon, but not a vertical.
Not a vertical.
India was
That is,
concerned
my
with
lord,
vertical.
subject to correction.
No,
my
it's
lord.
okay.
19-1.
My learned friend need not now talk about the Constitution bench.
Yeah.
Lawyers can always argue, but we have to.
I'm
We
not
are
a lawyer,
bound by
that
the
is.
Supreme Court judgment.
Yes.
And
So
that will
that
hold
is
the-
one. That is one. Secondly, there is a particular manner in which a secretary is appointed.
Yes.
The secretary is appointed on the basis of being the principal,
Yes.
and a secretary is elected.
Yes. Not
But what
selected.
has happened, the governing body president has made her this assistant
Yes.
teacher or assistant professor
A
secretary.
secretary giving her financial power,
Whatever may be,
Yes.
that is there, which you have challenged.
challenge it, and it was.
And
awaiting the
because of
decision.
your challenge,
Yes.
they have taken this vindictive attitude.
Yes.
And therefore you are before this.
Yes, and in fact, the suspension order, they say dereliction of duty. Well, if coming to the court is dereliction of duty.
Well,
only
it's
my
never
learned-
alleged in that manner.
No, that we will look into it.
Yes.
Yeah, but then also,
And
but
another-
this is your case.
Yes, and another point I have put in my reply,
Hmm.
point by point, I have countered that all allegation against me were an afterthought. Because they became wiser, because already I had filed two cases, first and the second. And so they bring in an allegation. Malad, the fact that they have committed a wrong is oblivious. Thing speaks for itself. Res ipsa loquitur. They first say that you, secretaryship, we never appointed you. And I could show document that when I was appointed, I was principal come secretary, it's their document. I don't manufacture document. I'm a selected principal. It is next to impossible that I'll manufacture. So the affidavit given by Mr. Hazarika is bringing an allegation that you have also manufactured a secretaryship. But in paragraph 9, they say that you are a secretary where we too sign documents. And I have annexed all the governing body meeting where I and the president signed it as
No,
secretary.
I wanted to look into these because not only that, how can you remove a secretary also?
Well, that is the case. Well, in fact, I applied. In fact,
Hello?
one thing I have to say, I prayed before the learned single judge that I need an interim protection. I was sensing, means a client also, that some punitive action will be taken because this is how the colleges function. And I've been in a college for 25 years, I know. So,
What has happened to the earlier matter?
which one?
Pending, madam.
That is pending, but the new governing body has already completed 3 years. And now the colleges, I have resigned, I have left the college. Now it is again going up.
You have left the college,
Means I have left the college.
Tezpur?
No, I'm talking, Malad, I'm talking about my own personal experience as a teacher.
Oh, no, not on that. I'm saying about the earlier petition.
Earlier petition is pending. That is
No,
pending.
should I tag along with this?
Yes, Lordship, this was the prayer I have.
So I tag along with this on Monday.
I'll bring those, right? It's there. Somehow
Kala-
today, my lord.
And you get hold of this,
Documents I have.
this,
Records, my lord.
these two documents and also the records, how it was placed before the government, who have taken the decision for suspending him.
My lord, I'll just point out one more factor. I'll place that. the meeting wherein she was kept out. She was not removed. She was kept out. That meeting she attended. She was there. She was explaining the position that a management, the school thing was not proper. So there are many things which are coming up. So we are keeping you aside. And another person from the college was allowed to, for that limited period, a period was prescribed. This resolution, she never
No,
wrote.
can you do that?
My lord, we have not removed her, my lord. We have not selected a new, my lord, person and brought in. We have just as an interim done it.
Is it so?
Yes, my lord.
This particular document.
My lord
at
will have page 30, that document is
No,
there.
page 24. Page 24.
Lordship, just a moment, my lord. Yes.
I understand would convey as per the government's resolution.
As per the
You are
resolution.
appointed as the secretary.
You were appointed, so that you were appointed as secretary, so and so on purely table, the duties and responsibilities as per so and so. And you are hereby asked to accept the responsibility and render your valuable service for your on purely temporary basis.
So,
my lord will see.
Then are you saying this particular appointment which has been given to the petitioner on temporary basis?
No, this is, my lord, to that lady who came in, my lord. Page 24 is to the new incumbent, my lord.
Malad, Ruby Dotto, my information is that they have now continued after March and Ruby Dotto still continues.
Because of this hanging thing, my lord, more understand, I would like to confess so-and-so was taken on so-and-so, appointed as secretary, so-and-so with effect from so-and-so on purely temporary basis. The duties and responsibilities will be as per ordinance of so-and-so. You are hereby requested to take response and render your valuable. Down, my lord, will see down below what is written there. Page 24.
The above matter is still pending.
And not confirmed by all the GB members. The principal and teacher representative strongly oppose the matter, and it is not accepted by the GB president. She has signed here, my lord. This resolution, my lord, she never.
She never signed it.
Because the book was with her.
Malad, he cannot make a.
I'm making it.
My client has not said it. Malad, if my client is now Jupiter Devi, I fail to understand.
See.
The Jupiter Devi is different person.
Malad, the two has signed it on the ground that the teacher's representative has already given a petition. Why is why is my learned friend
Kindly come to page 50.
He's not reading page 29.
Page 50, running page 50. Serial number 2 is the petitioner and serial number 13 is Jupiter Devi. They are different persons.
They are different persons.
Then this is what has been signed.
Signed SB. There is a signature, SB.
That is not one, two. There are two signatures.
Lordship. One is Jupiter Bora and the other one is the petitioner.
Yes.
And Lordship would find.
No. This, are you saying, because of this, you are saying that the petitioner was present in the meeting?
She was there in the meeting.
Are you saying that this particular document
Lordship
arose or was made at during the governing body meeting?
No, my lord. The governing body took a decision, directed the president to do it. And the president, my lord, issued this letter. When this letter was received by the petitioner here, she and one Jupiter Bora wrote this.
Absolutely. But writing this, would it mean that it has been accepted, but the petitioner was a part of the governing body meeting?
She was a part, my lord.
How do you know?
My lord, I'll say.
Another thing which my learned friend I like to point out, he's saying that he is for a temporary period. Malad, for a temporary period, does that give the right to the president to violate the statute and say that only for a temporary period?
I'm sorry, it's not the president, my lord.
On March, it was extended further. The president and
no, but the most important thing is to look into the Guwahati University statute. Where is it?
I'll place that.
Without that or regulation, it is very difficult to decide this matter.
No, Monday.
Heard Mr. D.K. Das, the learned counsel, appearing on behalf of the petitioner. Mr. U.K. Nair appears on behalf, senior counsel appears on behalf of the respondent number 3, 4. Ms. S. Sharma appears on behalf of the respondent number 5. Mr. Mr. So-and-so. He appears for respondent number 6.
4.
4. Mr. Swansea appears for respondent number 4 and Mr. K. Gogoi appears for respondent number 1 and 2. This court, upon hearing the matter, have raised certain queries pertaining to the Guwahati University statute as well as the Guwahati University regulation, which have been mentioned at serial number 8 and 11 in the rules and regulations of the respondent number 3 college society, rules and regulation of the Tejpur Law College Society. This court have also inquired as regards the records pertaining to the issuance of the order of suspension of the petitioner. Footstep. The learned counsel appearing on behalf of the respondent number 3 and 4. 3. Yes, 3, no? 3 and 4. 3 submits that he shall produce the Guwahati University statute as well as the Guwahati University regulations on the next date, as well as also produce the records which led to the resolution of the governing body to suspend the petitioner. Mr. Das, the learned counsel for the petitioner, submits that the instant writ petition is interlinked with WPC number
292 of 2023.
292/2023, in as much as taking into account the same, list the matter again on 16th.
Lordship, no, my lord, let it be Monday, my lord, 15th. Or, my lord, let it be on 18th, my lord. Either of these two. 16th, my lord, I will not be.
Let it be on 15th.
15th.
See, what happens now, this matter, I have to look into it.
Yes.
Lordship.
See, there are so many other.
No, my lord, my lord.
I'll leave it to you.
Other than 16th, my lord, 18th, if not otherwise inconvenient.
On 18th, on 18th of May,
Lordship.
2023.
One problem, he's on leave on 18th.
You will leave? Okay. Then on 17th.
17th, Lordship.
18.
Huh?
70 to 18, 13 and 18.
19th.
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 19th?
19th, Sunday.
Monday. Friday.
No worry. We'll take it up on 15th.
15th.
On
Lordship.
15th.
Lordship.
Obliged.
Lordship. Lordship.
On 15th,
I'll produce those, my lord.
along with WBC number 292. On ভৰাই দিব হা এইকেইটা জাজমেন্ট কেইটা দিছো ভৰাই
Remain as a partner.
এইকাত ভৰাই এইখিনি ভৰাই দিব
Remain as a partner.
My lord, will put it for further hearing so that it's
Huh?
further hearing, my lord, of partner.
Yes, partner.
So it comes.
further consideration.
Obliged.
And what 23?
Yes, Mr.
Yes, my lord.
Huh?
Sir, agreed by an order passed by Director of Higher Education, where an order was passed to issue. Department proceeding was there. They have issued an order.
Yes, what is the present status of the departmental proceedings, Mr. Gogoi?
Departmental proceeding is over, my lord.
Departmental proceedings attained finality, lordship.
Okay.
Petitioner is challenging the order passed by the lordship disciplinary authority, lordship.
But there is a provisions for appeal against the order passed by the disciplinary. That was
Is it
not-
so? Then why did I pass the order to that effect in that regard? Both councils are directed to obtain instruction as regards the present status of the departmental proceedings. Can't be.
There, lordship, some misconception from our side, lordship. Both lordship, two petitions is there, lordship. So we have.
Now departmental proceedings are over. What is the petitioner challenging here?
My lord, I have challenged because the departmental proceeding which was over and departmental proceeding, my lord, was an ex parte. Basis was on the basis of a statute under the Assam Financial Inspection of Department, sanction and implementation of scheme rules 1982. My lord, this is a third party.
Report numbering 12.
That was issued by the Assam Financial Inspection and a third party. That third party, my lord, when the inquiry was completed, that particular inquiry report was not furnished to us. And straight away it was sent to the department, that to the Director of Higher Education. And on the basis of that, my lord, they have
13/12/2017 order is this one. This order, departmental proceedings were drawn up against so-and-so, principal of so-and-so. He was suspended on so-and-so and accordingly a so-called notice was issued. So-and-so approved the inquiry report of inquiry minutely and in his office submitted his convinced of the charge related misappropriation to have been handled. It was reported that so-and-so engaged the demand and so-and-so. Having regard to this, we have inflict the punishment under Rule 7 of the Assam Discipline on the government servant. Convinced that the act of human servant I order that the entire amount of this amount be recovered from the delinquent government servant. Spread over a period of 48 months. 48 months gross notice date of retirement being in the month of June. Now thereafter, what happened regarding show-cause? Again, in different times, I could state that you have been given the maximum for submission of the reply to the show-cause notice. Right? What is this at page 54, Mr. Das?
50.
What is this document?
My lord, this document is arising out of page 50, my lord. We sought some time to file a reply at page 50. Thereafter, when we went to the department on 27/12/2017 at page
No,
50,
first and foremost, have you challenged this order?
which order? Yes, we have challenged.
13/12.
13/12. Yes, we
Where?
challenged this. Here.
Why?
In this case. We challenge only ground.
No,
that
why?
I'll tell why. I'll tell your lordship why. Because this financial irregularity was my initiated and was conducted by an agency under a statute. My lord, I have given the list. It's called the Assam Financial Inspection of Departmental Sanction Implementation Scheme Rules 1982. So there was an order passed by the department to file a written statement. We could not file a written statement. We were seeking some documents to be given to us. Now this they proceeded in ex parte. Now after the ex parte, my lord, an inquiry report was there. That inquiry report was not submitted to us. As per statute laid down by the Assam Financial Inspection, when the inspection is completed, there is a procedure under this Rule 7. Inspection completed, inquiry report has to be submitted to us to give a reply. That was not given to us. What they have done.
So your case is a case under Article 311.
Right, exactly. And there is one judgment I can show in Supreme Court that was done by a third party. Third party has inquiry completed. That inquiry report was not furnished to me. They forwarded to the Director of Higher Education. Director of Higher Education implemented that inquiry report. And on the basis of that, they said.
This inquiry was held under what provision?
Under the, my lord, the inquiry was held, and I have given the list under the Assam Financial Local Act, Volume 8 Local Act.
Difficult to get. We don't have the entire library here. You should have got a copy. We'll have it on some other day.
Well, can we just, with your lordship permission, can we list along with this because already I have been, my lord, retired from my service. My provisional pension is not being also being paid, not a single.
No. First and foremost, how will you get any provisional pension or anything to that effect? Now, with was there any stay?
There was a stay.
Huh?
Stay of this order. This order was.
But
stayed.
here the order of Justice Buzarbura says that the petitioner is aggrieved by an order under remand imposed on the petitioner pursuant to a proceedings under Assam Service Discipline and Appeal Rules.
Yes, right, my lord.
So is it under, therefore, the inquiry was held under what provision?
Under this Assam Financial Inspection Department.
Then why is on a different provision that appeal you are mentioning? Yes, you are referring to which one page, paragraph?
Volume 8.
Page?
Page, my lord, 372. 370, it starts, 370. 370.
370. Yes.
Some financial inspection of departmental sanction interest scheme rule 1982. Now, if your lordship kindly see the 7.
Yes.
Lordship got it? My lord, procedure for submission report. Director, after having complete check and inspection report referred to in Rule 5A, above shall submit a report to the Secretary Finance Department clearly bringing out all cases and nature of financial irregularities detected by him in the course of scrutiny of the relevant paper, document, etc., produced during check, inspection under Secretary Finance Department, shall thereupon proceed with the report in such a manner as may deem necessary in the interest of financial discipline economy, provided that a director, before submitting his report to the Secretary, Finance communicating any lapse or irregularity found at any stage of inspection, shall formally communicate to the executive agency his finding so as to give them an opportunity to express a lapse of irregularity. Now, what is executive agency? Is, my lord, at page 370, KL. Executive agency, my lord. Definition. Executive agency means the contractor or the person entrusted with the execution of the work. So he was.
Understood. This is for an inspection report.
Now,
whether the inquiry was done under the 64 rules, this is not an inquiry to that effect. The amount, the penalty which has been imposed upon you is by the disciplinary authority. But the disciplinary authority doesn't have the power to do so, does it?
Disciplinary authority has done on the basis of the report that was.
Understood. That is a different aspect of the matter which you need to ask them at the time of submission of your written statement of defense. If it is done under the rules of Rule 9.
My lord will kindly see the so-called at page 47. Page 47.
Yes.
The number one, that while we are working.
Yes, this is done under the rules of the discipline and appeal rules.
Kindly see that while you are working as principal, Vilasarpai College, we have misappropriated a huge amount of women hostess. The matter was inspected to a director of finance and
Now, did you submit a reply to this show cause?
No, I could not submit. Now
Why?
I sought for reply at page 49. We refer to, I have request you provide me relevant documents you have consulted, charging me expenses so and so.
Okay, then.
They have not given. Then,
I
my
have
lord,
received
I
the
sought
so-called
for-
reply
yes.
dated. Reply dated, which one? You
27/3/2017, I sought, my lord, at page 49 to provide me the copies of documents. At page 49. Now at page 50, I sought time to file reply to so cause. On 14/12/2017, I went there. And on 14/12, when I have gone, my lord, on 13/12/2017, they said already an order has been passed.
So where is the inquiry? That is why this court asked.
My lord, kindly peruse page 47 is the lordship show cause notice,
Ah,
and page 48 is the statement of allegation, lordship.
I've seen
List
it.
of witnesses is there, list of documents is there, lordship.
So this page 49
Lordship.
is the request made in terms of rule 9(2).
Lordship.
Now, after that, what happened?
Lordship, already list of documents is there, lordship, on the basis of which documents he has, lordship, that show cause has issued. Is a report of the Director of Finance Inspections, lordship. It
this
is an
is there.
enclosure list of
No,
documents.
anyways,
lordship.
thereafter, what did you do?
Lordship, he has seeking on last representation is lordship, date is not there. On 14/12/2017, lordship.
No, 14/12, let us leave
Lordship.
aside that.
Lordship,
Because you have already passed the order on 13/12.
lordship, lordship.
Now tell me,
Lordship.
the moment he requests for a reply, maybe it is useless. Thereupon, you are to pass an order to the effect that you have not submitted such and such things.
Lordship.
And as such, we may either go ahead with the inquiry or the disciplining authority wouldn't then conclude the finality and then ask him why he should not be imposed with the punishment and the, doesn't he have a right over there? Then?
Lordship, the order itself says that, lordship. Departmental proceeding drawn up against so and so, and he was transferred upon approval, and he was suspended on demand, later dated so and so cause notice was served upon him, along with statement of allegations, lordship. The following charges have been framed, lordship. Jointo Thakur, Deputy Director, Higher Education, Assam, was appointed the inquiry officer.
There is an inquiry officer.
Lordship.
Yes, it
Malaga
has
has
been done.
called for hearing in connection with the charges level against so and so.
And that
But-
report having been submitted, this is your suggestion.
But lordship, he did not turn up, lordship, and this is a appealable order also, lordship, as per section 15,
Understood.
lordship.
No, appeal now asking them to appeal after such a long time. Yes,
Your lordship will kindly send order of this court on 2/4/2018.
yes. What does it say?
When it was asked, the same question was asked. What is the, like, kindly see what is the.
2/4?
2/4/2018.
24.
24. 02/04/2018.
Yes.
Heard so and so of Council of Higher Education produced the record which indicates the inquiry report was sent to the petitioner Vilasari College, but it is unclear to record whether the same was actually served on the petitioner or not. The learned sending council of the produced a further information as to whether the same was actually served on the petitioner. If yes, to produce relevant material to indicate the same. At least I should. Inquiry report was not submitted to me, my lord. So is the
Yes, have you done that?
If it is yes, yes.
Lordship, the letter received from the college authority, it says that. Otherwise also,
Because
lordship,
once an inquiry report is submitted,
lordship,
he has a right to show cause.
lordship,
Only to the extent to say that the inquiry report is wrong.
lordship.
But that has been held to be a right by the Constitution Bench judgment in ECI. So that right he has.
And even then also, lordship, he has given the opportunity on 3 occasions, lordship, but he has not appeared, lordship, not turned up for hearing, lordship.
So it was not been given.
Lordship, it was given as per reports of the, it was returned back from the authority, lordship.
What given? It is not given.
Lordship, it was
The
sent.
letter is very clear, but unfortunately, the
Yeah,
said
it was
letter was
sent. It
returned
was-
to the college office by the postal department on 14/9/2017 with a note that the incumbent was out of station from 7 days.
I was not there, my lord. I was posted in Mondia College. My lord, I was initially in Vilasipura College as principal. Thereafter, my lord, what has happened? They were not.
Now you have retired?
I retired, my lord. I retired. I am not getting anything because of this order, my.
No, in
No
way,
provision.
now also you won't get anything till they issue that thing.
Even lordship, he has also filed one petition for pension also, lordship. Because in that particular case, lordship, the service book was not updated and it was not from the that Mondia
No,
college.
that is separate. Service book is updated now because there is an order. Why a service book is not updated? When I was Mandia College, my lord, from Bilasipura, I was transferred as a principal in Mandia College. Now service book has to be updated. They were not updating. We came before this court. Court said, why you are not updating? In person, the court's order, they updated the service book. Now I am not getting pension because of definitely of these all cases. Ultimately, these cases has to be settled. My only case is my
No,
lord.
no, now you see inquiry report, whatever may be, has to be brought to a logical conclusion.
Correct.
Yes, I can set aside the second one, the second order of 1312 for not serving you a copy. But now you submit your reply.
Sure, my lord. 1312 goes and I will submit reply on the basis of the inquiry report. On the basis, they don't know.
Where is the inquiry report?
Supply.
Is it a part of the records? No.
Regarding financial inspections,
Inquiry report, not the financial inspection.
then the record will reflect, Lordship. It will be in the record.
So get hold of that inquiry
Lordship,
report.
Lordship.
I think you file it by way of an additional affidavit. The inquiry report.
Then what will happen, my lord? Once we know it, then we'll lordship it.
No, once you file it, then I'll record that it is already there on record. On the basis of that, he will submit.
Lordship.
Or you can do one thing, you
I will-
can issue a show cause now by setting aside 1312, you can issue the show cause, and in the meantime.
From the stage of that.
Yeah, because the entire inquiry report won't go. for
Lordship,
that
Lordship.
purpose.
Inquiry report.
Inquiry report will remain only on the ground of non-violation of the
Non-violation.
ECL judgment we can do.
Lordship, Lordship. From the next date, Lordship, I will place the records, Lordship, and Lordship may.
But the only what difficulty is that there was a department, a third-party department, which has inspected, and ultimately there was an inquiry which was conducted. Maybe an ex parte inquiry, I may not have submitted. Now, if that inspection report has been, they have procedure as they have went ahead, inspected, but as per Rule 7, when the inspection was carried and there is inquiry, that inquiry report first would have been submitted to us before sending it to Director Higher Education. That's what 7 says. They have not done that also, my.
What 7? No, that is the immaterial. Whatever may be for the purpose, we are not concerned to that effect. We are only concerned to this aspect that at the time of issuing a show cause, you were given that particular inquiry report.
No.
Yes.
No, I'll just clarify. Maybe, my lord, some irregularities were there. So now, on the basis of irregularity, they appointed this particular agency, the Assam Financial Inspection Department. Now, my lord, on the day proceeded, ex parte maybe they proceeded. Rule 7 said you complete the procedure, an inquiry matter, and prepare an inquiry report. Now, that inquiry report, when you prepare it, then before sending it to the director, they have to serve to me to give a reply to their report. Number one, in the instant case, they have not given that inquiry report to me first. Secondly, without sending it to me, giving the opportunity of giving a reply on the basis of this inquiry which is conducted, the third party agency, they have sent to director. Now, director basing on the financial inspection report, they said that is okay. On the basis of that, an order has been passed.
No, the director has issued a show cause to you under Rule 9, asking you to show cause, and that inquiry report was given to you.
Yeah, right.
And you did not submit any reply. On the other hand, you said that kindly exonerate me. I am in very difficult times.
No, I said to the director, my lord, when this show cause was issued in 2017, I said, provide me with documents. I want to know.
In fact, it is a part of the document itself. That particular show cause categorically mentions that. That is the thing.
Page 48, Lord.
This document categorically shows list of documents, list of witness, list of documents, GB resolution, and report of the director financial inspection.
That was not, this was our specific.
No, it was not. With reference to, I have the honor to request you to kindly provide me with the relevant documents you have consulted before charging me with so and so. Then why you did not say that pursuant to receipt of this, that you did not get the report of the director?
Which of that?
This report of the director, which was a list of documents, in the list of documents, this document is to given to you.
Right.
And why haven't you mentioned that this document, I have not received it? You have not asked for this document. And in fact, in your reply also, which was given on this particular, you did not submit a reply. On 19/4, you only mentioned this document.
Right, that's I mentioned. Kindly see para 17, my lord, para 17.
Of what?
of my writ petition.
No. I don't go by the papers. I only see by the petition. This document is very clear. You may say many things on the affidavit out there, but why, what stopped you from writing out there that this document you are mentioning I have not got? Because that is the mandate of Rule 9(2) categorically says that whatever document you want an inspection, if you want a particular, for the purpose of defense assistance, you are to mention everything.
We have already asked certain
Even,
documents,
my lord,
provide my document at page 49, my lord. At page 49.
Kindly see the page 47, the down below.
47.
The last paragraph at page 47.
Yes,
You
47.
should submit your written statement in defense within 10 days from the date of issue of this communication, provided you do not intend to inspect of the documents which have relevance with the issues under inquiry. In case you intend to inspect those documents, you should write to the undersigned for the same within 7 days from the date of receipt of the and submit your explanation thereafter within 10 days thereafter. This is the mandate of Rule 9(2). It has been mentioned.
But my lord, this was done only Inspector, Director of Financial Inspection, and his expertise, he has done it, my lord. Expertise. Without giving a copy of inquiry report to me.
Who has done
This
expertise?
Director. Assam-
Director of which director?
This is Assam Financial.
No, we are not
Inspection.
concerned with that. That is not the subject matter out here. The subject matter is as regards the order of 13(2).
No, subject matter with great respect, 13(2) arises out of this because the inquiry report, which he relies on, the Director of Higher Education.
Now tell me, why didn't you challenge this? And you have got this report of the Director of Financial Inspection.
Yes.
Why didn't you challenge it then?
No, we have challenged it now.
When?
Challenged.
After getting this order of 13(12).
No, we challenged it.
When?
Additional affidavit we have challenged.
No,
it, my lord.
not by way of an additional challenge. Why haven't you challenged this aspect, this particular Director of Financial Inspection then?
On my lord, this Director of Inspection, when we came to know, my lord.
Inspection was done for financial irregularities.
whatever.
His presence is not required. The documentary
Your
lordship. it
presence,
was-
my presence is not required, my lord. It
It
will
is
be
a-
an
it is a
expertise.
doc- it is a
And what the
documentary
procedure
lordship on the
says,
basis of
and
the.
you, my lord, entire inquiry was based on his report. Expertise.
No, it is not based on his report alone. You have a right to say you did not, you chose not to say anything.
No, I have written to the authority, give me,
For
provide
what?
me the documents.
Now, did you ask for inspection of any of these documents?
Yes, I
Where?
will provide me with all documents.
then-
This is what is my
then-
case.
But here you say, kindly provide me with the relevant documents you have consulted before so and so, charging me with so that I can prepare reply to the so-called notice.
Yes.
And sir, thereafter what happened?
Thereafter, this is my lord, thereafter I went.
Yes, then
Then
what
I went.
happened?
At page 50, I have written a letter to them, my lord, 14/12/2017.
Page 50 is on 14(12).
550.
14(12) is different. Then
My
you
lord, may
say,
kindly page the content of this letter, lordship. Nothing
you
is
see,
there,
sir,
lordship.
at first, sir, I deeply apologize for not
Lordship.
replying to the so-called
Lordship.
notice dated so and so within reasonable time.
Yes.
Then you yourself have admitted this aspect of the matter.
And even also he says that as it is evident from the preceding paragraphs, wherein I have already stated I was a very bad physical as well as mental condition, due to which I was not in a position to reply the so-called notice dated so and so, lordship. And in this letter also he has nothing mentioned, not a single document, lordship. He has apologized for the delay part, lordship.
That is only. You have not made all these things. Now you are coming up with all these things. Nothing will happen. We can only give you, because Mr. Das, if you see the ECL engineering judgment out there, you have still a right upon a show cause being issued by them, a right to reply and say that the inquiry report which is to be given is not proper. And then on the basis of that, the Director of Higher Education or whoever it is can take a decision thereupon. So this is not the reply which is you are going to give in pursuance to what this court considers as so cause to be issued to you is not a reply that kindly waive all these penalties against me. No, it is a reply to show that you see the report which is being submitted by them, the inquiry report. I'm not saying about the earlier one as per that act. The inquiry report which have been submitted is not in accordance with law. And as such, the findings of the inquiry report is bad.
My lord, then 13/12/2017 will go and they will. punish
That
them.
is what I have been saying all along for the last 20 minutes. All the other councils are therefore saying, why is a debate going on.
My debate is going on because of this Assam finance.
That is not
section.
necessary. That is not necessary. You have completely kept yourself silent. You put this, bring this on the next occasion.
Lordship, Lordship.
Heard Mr. D. Das, the learned senior counsel, assisted by Mr. K. Mohammed. Mr. Igogo appears on behalf of the Higher Education Department. The case involved in brief, as could be seen from a perusal of the materials on record, is that pursuant to a report being submitted by the Director of Financial Inspection, SASAM, a show cause notice dated 27/3/2017 was issued by the Director of Higher Education to the petitioner in terms with Rule 9 of the Assam Service Bracket Discipline and Appeal Rules 1964. It, however, appears from the records that the petitioner did not submit a reply, although on 19/4/2017 sought for certain documents without specifying the respective documents he wanted to inspect. Be that as it may, it appears that on 13/12/2017, be that as it appears, that there was an inquiry report submitted by the inquiry officer on 29/8/2017, and in pursuance thereto, the order dated 13/12/2017 was passed. This order dated 13/12/2017 has been put to challenge before this court. It further appears from the records that this court, by an order dated 2/4/2018, had asked the learned counsel appearing on behalf of the Higher Education Department as to whether the inquiry report dated 13/12/2017 was furnished to the petitioner before passing the order dated, whether the inquiry report dated 29/8/2017 was furnished to the petitioner prior to passing of the order dated 13/12/2017. Today, while hearing the matter, the learned counsel for the Higher Education Department had submitted that from the instructions received from the, which college?
Principal Bilasipara College, Lordship.
From the principal Bilasipara College, that there was an attempt being made to solve this inquiry report upon the petitioner, but the same could not be served on account of the petitioner not being there present in his station for 7 days. And accordingly, the said document was returned, document which included the inquiry report was returned back. So, taking into account the said aspect of the matter, this court fixes this matter again on when
Monday.
I've almost given all these things, only remaining is 2-3 things.
Monday.
On,
So if it is put by way of affidavit, then Lordship, at least Lordship.
on 22nd of May, 2023.
Further hearing. Further hearing. No, this has been heard on.
Lordship, oblige, Lordship.
Paragraph 23, 24, 25.
Yeah.
ECI.
ECI.
Lordship.
That is your case.
24.
Go. Yes, Mr. Dhar, he's entitled to pension. That 6 years aspect doesn't have any good in view of Sanjita Roy. Now, he was regularized on 22/7/2005. And he retired on 36/2007. So,
Yes, he has completed, my lord, 18 years. If we do not deduct that 6 years, he has completed 18 years, 2 months, 29 days.
minus 6. But you have deducted 6 years.
No, my lord. If we do not deduct,
It's 18 years. Then
it's 18 years.
And then
if you deduct, it will come 12 years, 2 months, 29.
we are not there on that. He can't deduct it. Then 18 years, why he won't get then? Once he is regularized, at least for the qualifying period, that has to be taken into account. May not be for the earlier period, but for at least for 10 years. Because 108B says that he will be entitled to if he has 10 years of.
My lord, yes, 108. If I read, my lord, after a service of not less than 10 years, a pension not exceeding the following amount. Completed 6 monthly periods.
Mr. Dhar, let us not make this quote a quote of the Accountant General. That is for Mr. Ardhar to do that, the other one. But why this period should not be taken once it is regularized? What do you mean by regularized?
Regular. Sir, my lord, he was regularized in 2005.
They were condoning what has happened already. Why?
That aspect, my lord, has to be looked into, my lord.
Huh?
Because otherwise, qualifying service for pension is 20 years.
No. Where do you get this 20 years business?
My lord, this 10 years is, my lord.
No,
Not for-
10 years is the qualifying service, not 20 years. Below 10 years, a person is only going to get the terminal benefit, C151. But the 108 says that if you have the minimum of this 10 years, not less than 10 years, then you are entitled to this.
Yes, but my lord, if I go into that again table, my lord, it starts from 20 years. That calculation table, my lord, in 108, my lord, that was a trying to, my lord, negotiate.
After service of less than 10 years, read 10A, 180.
10.
After service of less than 10 years,
Yes, my lord.
a gratuity not exceeding except in special cases and under the orders of the governor up to a maximum of 12 months or emoluments. 1/2 months emoluments for each completed 6 years period of service. If the emolument, so if it is less than 10 years, it's a gratuity. That's the terminal gratuity which he gets. Now, after a service of not less than 10 years, means above 10 years, a pension not exceeding the following amounts has to be paid. So the period is only after the qualifying service is 10 years.
After a service, not the.
Kindly see it. No, come at serial number 20.
My lord.
See 20. Then you see then. So all these things. 10. Completed 6 monthly periods of qualifying service. 6 monthly periods. Means that is why 20 has come.
Yes.
10, that is why it is 20. 1 to 2019, there is no mention because of 108A.
Yes.
And when a person completes 10 years, it will be 20. That is the 6 monthly period. And therefore, the 10th, 6th average emoluments will be 2,000 a year or 162 by 2/3 a month. This is the catch.
Yes, my lord.
Isn't it? So we give them the pension.
Let AG calculate what he will get.
Yes.
We have given the terminal benefit. We have released the terminal benefit.
No, you have reduced the term, you have given the terminal benefit, so that you reduce it while giving them the area. And that day I passed an order to who was there in this matter, some matter. You were there, Mr. Dhar? That PD, that was also a PWD matter. What's a similar order? On this type, by which he is entitled to this pension. You were there, Mr. Sharma? No, no. Heard Mr. A. Dasgupta, the learned counsel, appearing on behalf of the petitioner. Senior counsel assisted by Mr. A. Kundu, the learned counsel, appearing on behalf of the petitioner. Mr. Ardhor appears on behalf of the respondent number 3 to 5.
No, I am.
Rahul Dhar. Rahul Dhar, you appear for respondent number 3 to 5. Mr. Rupak Dhar appears on behalf of the respondent number 6.
5.
Huh? 5.
Here it is.
6.
In my copy it is 5.
Names are confusing now also. Respondent number 6. Mr. Dibora appears for respondent number 1 and 2. The case of the petitioner herein is that the petitioner was initially appointed on 1/4/1989 as a master roll worker in the Public Works Department, Mohur Roads Division. Thereupon, his service was regularized on 7/10/2005 with effect from 22/7/2005. The petitioner retired from service on 30/6/2007. However, the respondent number 6 had rejected the pension proposal of the petitioner on the ground that the petitioner had served only for a period of 12 years, 2 months, 29 days after deducting 6 years, which is less than 20 years. The case of the petitioner is that the petitioner's service have been regularized with effect from 22/7/2005. And the same therefore dates back to the date of the petitioner's initial appointment. That is from 1/4/1989. And as such, the service period of the petitioner for pension is 18 years, 2 months, 29 days. This court had, by an order date in 19/4/2023, had issued notice making it returnable today. The learned counsel appearing on behalf of the respondent number 3 to 5 has submitted an instruction from the executive engineer PWD, wherein it has been mentioned that the total length of service of the petitioner from the date of his joining till his date of retirement was 18 years, 2 months, 29 days. And as per Rule 108 of the Assam Service Pension Rules 1969, the petitioner would be entitled to get pensionary benefits as the remaining service period after deducting 6 years is 12 years, 2 months, 29 days. But unfortunately, the incumbent was not given any benefits besides the amount received as terminal gratuity granted by the respondent number 6 in the month of December 2017. The said instruction is kept on record and marked with the letters X. This court, it is at this stage, it is relevant to take note of that this court, in the case of Sanjita Roy versus so-and-so, reported in so-and-so, had categorically held that the deduction of 6 years in respect to master roll workers was violative of Article 14 of the Constitution. And accordingly, under such circumstances, the deduction of 6 years from the, while computing the pensionable service of the petitioner, is contrary to the law declared by this court in the case of Sanjita Roy Supra. Now, it would further be seen that if the period of 6 years is being taken, the total service of the petitioner would be 18 years, 2 months, 29 days. In view of the fact that the petitioner's services were regularized, the same would date back to the date of the petitioner's initial appointment. And as such, কি লিখিলে লাভ হৈছে? Now, tell me one thing. Would it date back to the date of his initial appointment?
Affect my regularization.
Hmm?
If you go by what you have,
No, why I'm saying so? Why I'm saying so, in view of a recent judgment of Justice M.R. Shah, there what has happened, the benefit was given only for 10 years, being the qualifying service. And there was a rationale. The reason was mentioned, saying the reason why it was given is those other persons who have been regularly selected, just for example, a person who is regularly selected, he has worked all the while in a regularly selected post, and then he gets his pension from then. Could it be the same yardstick being applied for a person who has not been regularly selected and given so and so? Now, what has happened in this case, I think, this matter. This judgment was delivered very recently by the Supreme Court in the case on 28th of April 2023, in the case of Uday Pratap Thakur versus State of Bihar. Now, what these people did, they wanted that from the date of their regularization, once they were regularized, they were asking for the pension from that period. Now, the Supreme Court said in this judgment, insofar as the submission on behalf of the appellants that the entire service rendered as work charge should be considered and accounted for the purpose of pension, oblique the quantum of pension is concerned, the same cannot be accepted. If the same is accepted, in that case, it would tantamount to regularizing the service from the initial appointment as work charged. As per the catena of decisions of this court, there is always a difference and distinction between a regular employee appointed on a substantive post and a work charge employee working under a work charge establishment. The work charge employees are not appointed on substantive posts. They are not appointed after, they are appointed after due process of selection and as per the recruitment rules. Therefore, the service rendered as a work charge cannot be counted for the purpose of pension or the quantum of pension. However, at the same time, after rendering of service as a work, now here the catch comes. However, at the same time, after rendering of service as a work term for number of years, and thereafter when their services have been regularized, they cannot be denied the pension on the ground that they have not completed the qualifying service for pension. That is why the service rendered as work charge is to be counted or considered for the purpose of qualifying service for pension which is provided under such. I think this analogy would help us instead of saying anything on the initial appointment, because then there will be a discrimination. Isn't it, Mr. Raghu?
Yes.
And in fact, what happens if I pass an order without thinking that, and that thing, another 10 petitions comes for the similar relief. Now, in view of the same, the question therefore arises as to whether the entire service period of the petitioner could be taken into consideration for the purpose of pension. For that purpose, this court finds it relevant to refer to a judgment of the Supreme Court, recent judgment of the Supreme Court dated 28/4/2023 in the case of Uday Pratap Thakur and another versus the state of Bihar and others, bracket civil appeal number 3155/2023, wherein also the question arose as to whether the entire service rendered as a work charge should be considered and or counted for the purpose of pension or the quantum of pension is concerned. The Supreme Court, drawing a distinction between a person who have been regularly appointed on a substantive post and a work charge employee working under the work charge establishment, held that the entire, that giving the benefit from the date of their initial appointment would be regularizing the petitioner, regularizing the persons concerned who have been appointed on work charge establishment and subsequently regularized from the date of the initial appointment. The Supreme Court further took into another aspect into consideration, that after rendering of service as a work charge for a number of years and thereafter when their services have been regularized, such persons cannot be denied the pension on the ground that they have not completed the qualifying service for pension. And it is under such circumstances the Supreme Court held that if pursuant to the regularization, a person does not have the qualifying service, his earlier period of service, which will lead to the qualification, lead to the qualifying service for pension, shall be taken into consideration. Paragraph 6.2 6.3 and 7 of the said judgment being relevant is quoted herein under. In the instant case, although the petitioner herein was appointed on 1/4/1989 as a master roll worker in the Public Works Department, but he was regularized on 7/10/2005 with effect from 22/7/2005. By the time the petitioner retired on 30/6/2007, the petitioner did not have the qualifying service pursuant to his regularization. However, taking into account the judgment of the Supreme Court in the case of Uday Pratap Singh Supra, this court feels that the ends of justice would be met if the earlier period of service rendered by the petitioner is taken into consideration only for the purpose of attaining the qualifying service in terms with Rule 108B of the Assam Service Rules 1969. In that view of the matter, this court therefore directs that the period of service therefore disposes of this writ petition, holding inter alia that the petitioner having minimum qualifying service of 10 years would be entitled to pension in terms with Rule 108B of the Rules of 1969, and the respondent number 6 shall do the needful in that regard. You have to submit a proposal again.
Yes, I will have to submit the proposal.
And the respondent number 3 and 4 shall do the needful on the basis of the instant judgment, instant order, and do the needful upon submission of a certified copy of the instant judgment, this order to the respondent number 3, who shall further process the proposal to the respondent number 6, who shall do so, who shall do the needful as expeditiously as possible, taking into account that for the last 16 years after the retirement of the petitioner have not received anything. This court further makes it clear that while ascertaining the area pension of the petitioner, the amount paid on account of terminal benefits, gratuity shall be reduced. The said exercise be done within a period of 4 months from the date of the certified copy of the order is served upon the respondent number 3.